Okay.
Mr. Chairman, I move to adjourn. I ask for a roll call vote.
We're not in executive session. We will continue as planned.
Mr. Chairman, may I be recognized, sir? Mr. Chairman, I appeal to the chair to recognize myself or one of my colleagues.
You're out of order.
Mr. Chairman, I appeal to be recognized on your sense of decency and integrity. Even the documents you have requested, Mr. Chairman, even the ones that you said, the limited documents you have requested, this committee has not received. And the documents we have, you, sir, have labeled committee confidential. They should be transparent. This committee, sir, is a violation of even the values I've heard you talk about time and time again, the ideals that we should have. What is the rush? What are we trying to hide by not having the documents out front? What is with the rush? What are we hiding by not letting those documents come out? Sir, this committee is a violation of the values that we as a committee have striven for, transparency. We are rushing through this process in a way that is unnecessary. And I appeal for the motion to at least be voted on.
Mr. Chairman.
At least let's have a vote, because when we wrote you a letter on August 24th
Senator.
asking to have a meeting on this issue, you denied us even the right to meet. So here we are having a meeting. Let's at least debate this issue. Let's at least call this for a vote. I appeal to your sense of fairness and decency, your commitments that you've made to transparency. This violates what you have even said and called for, sir. You've called for documents, you yourself, limited documents. We thought there should be more. We have not received the documents that you have even called for. So, sir, based upon your own principles, your own values, I call for at least to have a debate or a vote on these issues and not for us to rush through this process.
Mr. Chairman.
Senator.
Mr. Chairman,
Senator,
I've heard calls for
I'd like to
regular
respond.
order.
I'd like to respond to Senator Booker. Senator Booker, I think that I respect very much a lot of things you do, but you spoke about my decency and you spoke about my decency and integrity, and I think you are taking advantage of my decency and integrity. So. Okay.
The order, it is regular order for us to receive all the documents, that this committee is entitled to.
Okay.
Mr. Chairman, it is also,
I think that
Mr. Chairman, it is also not regular order for the majority
Senator
to require
Rono.
the minority to pre-clear our questions, our documents, and the videos we would like to use at this hearing. That is unprecedented. That is not regular order. Since when do we have to submit the questions and the process that we wish to follow to question this nominee?
Senator,
So I'd like your clarification. I'd like your
Senator
response
Rono,
on why you are
I
requesting
would
the
ask
minority
that
to
you,
submit our questions to
I ask
you.
that you stop so we can conduct this hearing the way we have planned it. Maybe it isn't going exactly the way that the minority would like to have it go, but we have said for a long period of time that we were going to proceed on this very day, and I think we ought to give the American people the opportunity to hear whether Judge Kavanaugh should be on the Supreme Court or not. And you have heard my side of the aisle call for regular order, and I think we ought to proceed in regular order. There will be plenty of opportunities to respond to the questions that the minority is legitimately raising, and we will proceed accordingly.
Mr. Chairman, under regular order, may I ask a point of order, which is that we are now presented with a situation in which somebody has decided that there are 100,000 documents protected by executive privilege, yet there has not been an assertion of executive privilege before the committee. How are we to determine whether executive privilege has been properly asserted if this hearing goes by without the committee ever considering that question? Why is it not in regular order for us to determine before the hearing at which the documents would be necessary whether or not the assertion of privilege that prevents us from getting those documents is legitimate or indeed is even an actual assertion of executive privilege? I do not understand why that is not a legitimate point of order at this point, because at the end of this hearing it is too late to consider it.
Mr. Chairman, if I might add to this, on the integrity of the documents we've received, there really is no integrity. They have alterations, they have oddities, attachments are missing, emails are cut off halfway through a chain, recipients' names are missing. Many are of interest to this committee, but it's cut off. The National Archives hasn't had a chance to get us all that we want, even though you said on your website the National Archives would act as a check against any political interference. But I check after the hearing's over. There's no check. I think we ought to at least have the National Archive finish it, and to have, for the first time, certainly in my 44 years here, to have somebody say there's a claim of executive privilege when the president hasn't made such a claim just puts everything under doubt. What are we trying to hide? Why are we rushing?
I can answer all the questions that have been raised, but I think if I answer those questions, it's going to fit into the effort of the minority to continue to obstruct, and I don't think that that's fair to our judge. It's not fair to our constitutional process. But let me respond to those now, and then maybe we can proceed. My colleagues on the other side are accusing the administration of using executive privilege to hide documents from the committee. I want to say why they're wrong. Unlike President Obama's assertion of executive privilege during Fast and Furious is one example, this assertion is not legitimate. Judge Kavanaugh was a senior lawyer in the White House. He advised the president on judicial nominations, provided legal advice on separation of powers issues, and handled litigation matters. As the Supreme Court has put it, quote, unless the president can give his advisors some assurance of confidentiality, a president could not expect to receive the full and frank submissions of facts and opinions upon which the effective discharge of his duties depends, end of quote. The issues Judge Kavanaugh worked on are exactly the sort of issues that require, according to the Supreme Court, some assurance of confidentiality. We in the Senate and everyone else in America expect exactly the same sort of confidentiality. Most senators would not agree to turn over their staff's communication to anyone. For example, we didn't ask that Judge Kagan's records for her service with then Senator Biden be turned over during her nomination. And because of attorney-client privilege, everybody has a right to keep communications from their lawyers out of government hands. We therefore didn't ask for Justice Ginsburg's documents from her time with the ACLU. We didn't ask for Judge Sotomayor's confidential documents from her time in private practice. It can't be that the Senate and the ACLU are entitled to more protection than the President of the United States. And then I will speak to the fact about 42,000 pages. Last night, we received additional documents for the committee's review. These were documents we requested before the hearing, and we received them before the hearing just as we requested. The majority staff began reviewing the documents as soon as they arrived and has already completed its review. There is thus absolutely no reason, that's no reason to delay the hearing. We have received and read every page of Judge Kavanaugh's extensive public record This includes 12 years of his judicial service on the most important federal circuit court in the country, where he authored 307 opinions and joined hundreds more, amounting to more than 10,000 pages of judicial writing. We also received and read more than 17,000 pages of his speeches, articles, teaching materials, other documents that Judge Kavanaugh submitted with his questionnaire, the most robust questionnaire this committee has ever issued. And of course, we received and read more than 483,000 pages of documents from Judge Kavanaugh's extensive executive branch service. This is more pages than the last 5 Supreme Court nominees combined. In short, this committee has more materials for Judge Kavanaugh's nomination than we have had on any Supreme Court nominee in history. Senators have had more than enough time and materials to adequately assess Judge Kavanaugh's qualifications, and so that's why I proceed. I know that this is an exciting day for all of you in the family and all the people that are close to Judge Kavanaugh, and you're rightly proud of the judge. The American people get to hear directly from Judge Kavanaugh later this afternoon. After this confirmation hearing and process is finished, I expect Judge Kavanaugh will become the next Associate Justice of the Supreme Court. Welcome again, Judge. Before I begin, I would want to give you, Judge, an opportunity to introduce your family.
Thank you, Mr. Chairman and Senator Feinstein. And
push the red button if it's not on.
Will we have opening remarks?
Yes, we're going to have. Yeah.
Thank you, Mr. Chairman and Senator Feinstein and members of the committee. I'm honored to be here today with my family, my wife, Ashley, proud West Texan, graduate of Abilene Cooper High School, now the town manager of our local community where we live. Our daughters, Margaret and Liza. Thank the committee for arranging a day off from school today. My mom and dad, Martha and Ed Kavanaugh. My aunt and uncle, Nancy and Mark Murphy. And my first cousins, Rosie and Elizabeth Murphy. I'm very honored to be here, honored to have my family here. I'm here because of them. Thank you, Mr. Chairman.
We're delighted to have your family here. Before I make my opening remarks, I want to set out the ground rules for the hearing. I want everyone to be able to watch the hearing without obstruction. If people stand up and block the view of those behind them or speak out of turn, it's not fair or considerate to others, so officers will immediately remove those individuals, and I thank the officers for doing the work that they have to do. We'll have 10-minute rounds of opening statements with each member. The ranking member and I may go a little over 10 minutes, but I'm going to ask everyone else to limit your remarks to those 10 minutes. I hope everyone will respect that. We plan on taking a 15-minute break after Senator Cruz's opening statement. After all the opening statements by senators are complete, we'll take another 15-minute round break to turn to our introducers, who will formally present the judge. After that, I'll administer the oath to the judge, and we'll close that portion of today's hearing with his testimony. Tomorrow morning.
Mr. Chairman, when will we review Senator Blumenthal's motion to adjourn?
What's your question?
I renew my motion to adjourn, Mr. Chairman. I think we're entitled to a vote on it.
Yeah.
The responses that, Mr. Chairman, you've given with all due respect really fly in the face of the norms of this committee, our traditions, and our rules.
Okay. Mr. Chairman, if I might add an additional point, I agree with my colleague. It is striking, given your long history of encouraging the executive branch to treat minority requests equal with majority requests, that you discouraged the National Archives from responding to Ranking Member Feinstein's request, which she tried to craft with you to be identical to the request for records from Justice Kagan. We should not be proceeding until we have the full documents that allow us to review the judge's records.
And, Mr. Chairman, last Friday we learned that nearly 102,000 pages of documents from Judge Kavanaugh's work in the White House counsel's office are being withheld from the committee and the public based on a claim of constitutional privilege. Executive privilege has never been invoked to block the release of presidential records to the Senate during a Supreme Court nomination. This includes when Justice Kagan was nominated to the Supreme Court, as well as Justice Roberts. Yesterday, my colleagues and I sent a letter to the White House counsel asking that the president withdraw his claim of privilege over these documents so that they can be made available to this committee and to the American people. We have not yet received a response to that letter, so we should not be proceeding until we have a response and these documents have been available. It is 102,000 documents.
And Mr. Chairman,
my motion to adjourn, Mr. Chairman, would raise this issue of executive privilege and whether it has been properly asserted for reasons that have been outlined well by my colleague, Senator Whitehouse. There is no valid claim here of executive privilege. Even if there were one, it has not been properly asserted. The question is, what is the administration afraid of showing the American people? What is it trying to hide?
And Mr. Chairman, using your own words in the statement you just read, you said, I quote, "We've had more than enough time to review the documents." Sir, we just got a document dump last night of over 40,000 pages. I would venture to say not one senator here has had time to read through those 40,000 pages. And so we are continuing to rush through this process, a process that deserves to be scrutinized. I support Senator Blumenthal's motion to adjourn, and I hope that we can at least have a vote on that motion.
Mr. Chairman, I think you'd be hard-pressed to find a court in the country that would not give a party litigant a continuance when the party on the other side did a 42,000-page document dump after close of business the night before trial.
Mr. Chairman, we waited for more than a year with a vacancy on the Supreme Court under the direction of your leader in the United States Senate, and the Republic survived. I think the treatment was shabby of Merrick Garland and President Obama's nominee. The fact that we cannot take a few days or weeks to have a complete review of Judge Kavanaugh's record is unfair to the American people. It's inconsistent with our responsibility under Article 2, Section 2 of the Constitution to advise and consent on Supreme Court nominees.
Senator Cornyn, you want to speak?
Mr. Chairman, thank you. I'll be very brief. I would just say that Senator Whitehouse has suggested that we handle this hearing like a court of law, but I would suggest that if this were a court of law, that virtually every member of on the dais on that side would be held in contempt of court.
Oh, come on.
Because this whole process is supposed to be a civil one where people get to ask questions and we get to get answers. And that's the basis upon which we are to exercise our constitutional responsibilities of advice and consent. So I would just suggest we get on with the hearing.
If my colleagues...
Mr. Chairman, if I could just respond. Mr. Chairman, if I could just respond.
Mr. Chairman.
If we could just respond to that.
I would...
Sir.
You can respond, but just a minute. If people wonder why the chair is so patient during this whole process, I have found that it takes longer to argue why you shouldn't do anything than let people argue why they want it. These things are going to be said throughout this hearing. We're going to be in session Tuesday, Wednesday, Thursday, Friday, Saturday, Sunday, till we get done this week. So however long people want to take, we're going to not necessarily accommodate all obstruction, but if people got something to say, this chairman's going to let them say it. But it gets pretty boring to hear the same thing all the time. Senator Booker, make it quick, please.
I really appreciate the deference, Mr. Chairman. The question was, why would we want to delay this? And this is not an attempt to delay. This is an attempt to be fully equipped to do our constitutional duty, which everybody, Republicans and Democrats on this committee, take seriously. It is very hard to perform our role of advise and consent when we do not have a thorough vetting of the background of the candidate in areas which the candidate himself has referred to as the most formative part of his legal career, where he himself has talked about how important this period of his life is. we're denied the full vetting. And, sir, this is not something that Democrats are asking for. I remind you that you yourself asked for a limited set of documents for when he was in the White House counsel's office. You yourself set that standard. And even on that limited standard, sir, we have not received the documents. And then even the documents, we've received 7% of them. Almost half of those have been labeled committee confidential that cannot be put before the American people, which further undermine and inhibit our ability to ask questions to thoroughly vet this candidate and advise and consent the President of the United States. So, sir, just on the basic ideals of fairness, the traditions of this body, we should have a thorough understanding of the nominee that's put before us so that we can vet them. To go into this hearing without those documents is an undermining of the constitutional role to which we have all sworn an oath to uphold.
Mr. Chairman, I have great respect for my colleague from Texas.
I would like to respond to Senator Booker, and then Senator Feinstein has asked for the floor.
Mr. Chairman, I asked to respond to my colleague from
Senator Booker.
Texas. Mr. Chairman.
Senator Booker, using a standard set by two members of your political party in the caucus, and I'm going to phrase because I don't have the exact quotes in front of me, but recently Senator Schumer said from the floor, the best judge of whether or not somebody should be on the Supreme Court is decisions that they've made at lower courts. Senator Leahy said something similar to that when Senator Sotomayor was before us, that we know what you have done in a lower court. That's the best basis for knowing whether or not you ought to be on the Supreme Court. So we have 307 cases that this nominee has written decisions on as a basis for that, and we've got 488,000 other pages, and maybe the senators haven't read them, but their staff is fully informed, because last night before 11 o'clock on the 42,000 pages that have come to our attention, the staff on the Republican side has gone through them.
But, sir, then why did you ask for the White House counsel documents? They were not germane to this hearing. Why would you even ask for them?
Senator Feinstein.
For the record, that's a rate of 7,000 pages per hour. That's superhuman.
Yeah.
They're amazing. They're amazing.
Mr. Chairman,
Yes,
if I may,
I've
been through 9 Supreme Court hearings.
Is this your opening statement?
It's part of it.
Why don't you make your opening statement?
Shall I?
Yeah, would you please?
Mr. Chairman, I asked for an opportunity
pending.
to respond to my colleague from Texas because he is directly challenged us with.
I said you're out of order.
Well, Mr.
Senator
Chairman,
Feinstein.
I ask in the process of regular order an opportunity to respond to what I believe was a personal attack.
I'd like to have you give Senator Feinstein the courtesy of listening to her opening statement.
Well, I was just going to say some things. And you heard that this is my 9th hearing. And I think we've got to look at this. These are very unique circumstances. Not only is the country deeply divided politically, we also find ourselves with a president who faces his own serious problems. Over a dozen cabinet members and senior aides to President Trump have resigned, been fired, or failed their confirmations under clouds of corruption, scandal, and suspicion. The president's personal lawyer, campaign manager, deputy campaign manager, and several campaign advisors have been entangled by indictments, guilty pleas, and criminal convictions. So it's this backdrop that this nominee comes into when what we're looking at is he within the mainstream of American legal opinion, and will he do the right thing by the Constitution? We are also experiencing the vetting process that has cast aside tradition in favor of speed. When Justice Scalia died, Republicans refused to even a meeting in their office with President Obama's nominee, and held the seat open for 1 year. Now, with a Republican in the White House, they've changed their position. The majority rushed into this hearing and is refusing to even look at the nominee's full record. In fact, 93% of the records from Kavanaugh's tenure in the White House as counsel and staff secretary have not been provided to the Senate, and 96% has not been given to the public. We do know what the White House thinks of this nominee. Don McGahn, the White House counsel, spoke to the Federalist Society and made clear Brett Kavanaugh is exactly the kind of nominee the president wanted. In his speech, Mr. McGahn discussed President Trump's 2 lists of potential Supreme Court nominees. One, he said, was filled with mainstream candidates. The other list included candidates that are kind of too hot for prime time, the kind that really would be really hot in the Senate. Probably people who have written a lot. We really get a sense of their views, the kind of people that make people nervous. That's a quote. Now, what I'm saying, this is the backdrop into which we come into this situation. So, yes, there is frustration on this side. We know what happened with the prior nominee, the last one President Obama presented to us. He never even got a meeting. He never got a hearing. He never got a vote. And now the rush to judgment and the inability to really have a civil and positive process ends up being the result. I really regret this, but I think you have to understand the frustration on this side of the aisle. Everyone on this side of the aisle wants to do a good job. They want time to be able to consider what the findings are. And there are tens of thousands of pages of emails and other items which could constitute findings on a whole host of major subjects that this nominee may be faced with. And they're serious. The torture issues, all of the Enron issues that he's been through, all of the kinds of things that we want to ask questions about. So, I mean, understand where we're coming from. It's not to create a disruption. It's not to make this a very bad process. It is to say, majority, give us the time to do our work so that we can have a positive and comprehensive hearing on the man who may well be the deciding vote for many of America's futures.
Mr. Chairman, I renew my motion to adjourn and Senator Harris's motion to postpone. I ask for a second.
Second the motion.
Mr. Chairman, I ask for a vote.
Yeah.
I ask that we reconvene in executive session
I
and have a
shouldn't have
vote.
to explain to you, we're having a hearing. It's out of order. We're not in executive session. That'd be the proper forum for entertaining motions.
I ask that we reconvene in executive session. We
won't vote on Senator Blumenthal's suggestion. We won't follow your suggestion.
Well, it's a motion, Mr. Chairman.
To go into executive session. Motions would not be proper at this time.
Mr. Chairman, it's a pending motion before the committee.
Yeah.
Mr. Chairman, if there is no vote on this motion, which has been properly seconded and which could be given a vote in executive session, this process will be tainted and stained forever. I'm asking, as a member of this committee, it's my right to do so, that we vote on my motion to adjourn and Senator Harris's motion postpone, and that we do it in executive session, which can be easily and quickly convened right now.
Yeah. The motion is out of order.
Sir, then I make a very clear and simple motion to move into executive session so that Senator Blumenthal's motion may be considered.
The motion is out of order.
Well, they're not out of order, Mr. Chairman. They're properly before this committee. Simply saying so, with all due respect, and I have great respect for the chairman, doesn't make them so. It doesn't make them out of order just because the chairman rules that they're out of order. We have a number of excellent lawyers in this room, and I ask that this body now do what its responsibility is, to have an executive session so we can vote on a motion to adjourn, and then we can deliberately and thoughtfully consider the documents that have been presented and also review the committee documents that have been marked confidential without any reason or rationale.
The motion is denied.
Sir, how long would that take? 10 minutes for us to have a motion and a vote on this process? I don't understand what the rush is that we can't even let senators vote on what is a very important motion germane to our constitutional duties before this body, before we proceed. I don't understand. It won't take that much time. What is the rush? What are we afraid of to hold a vote on the motions before us?
Mr. Chairman. Mr. Chairman.
Senator Kennedy.
Thank you, Mr. Chairman. I have a question about the process. I understand my colleague's point, and I understand they feel strongly about this. But what are going to be the ground rules today? Are we going to be allowed to interrupt each other, interrupt a witness? Yeah. Are we going to, should we seek recognition from the chair? I just want to understand the ground rules.
Proper respect and decorum, plus how we normally have done business in a hearing like this. We wouldn't be having all these motions. You're new to the Senate, so this is something I've never gone through before in 15 Supreme Court nominations that I have been since I've been on here. And every member, I was interrupted before I got a chance to say what the agenda for today, but every member is going to get 10 minutes to make their remarks, and then we will go to the introducers of Judge Kavanaugh. There will be 3 of those. They will take the usual time of introducers, and then we will have the swearing in of Judge Kavanaugh, and then we will have his opening remarks, and then we will adjourn for today. We'll reconvene at 9:30 on Wednesday and Thursday. Each member will have 30 minutes to ask questions or make all these points they're making right now for the first round. Then there will be a second round of 20 minutes each. So every member is going to get 50 minutes to ask all the questions or make all the statements that they want to make in regard to anything about this candidate or anything about how this meeting's being conducted. And then we will go late into Wednesday night or Thursday night till we get done with the questioning of Judge Kavanaugh. And then on Thursday, we're going to have 3 panels of 6 each, evenly divided for people that think Judge Kavanaugh should be on the Supreme Court and people that think he should not be on the Supreme Court. And we hopefully get that done Friday, but if we have to go Saturday and Sunday, we'll go Saturday and Sunday until we get it all done.
Mr. Chairman, how can we possibly
Does that answer your question, Senator Kennedy?
Well, if I want to, yes, Mr. Chairman, I appreciate it. If I want to say something, do I need to be recognized by the chair?
That would be the way that it's handled. I've tried to explain to you, I'm going to be patient, because sometimes if you aren't patient and you argue why something shouldn't be done, it takes longer than it does just to listen to people. But I don't think we should have to listen to the same thing 3 or 4 times.
Well, patience is good, Mr. Chairman. But I just want to understand the rules. If I want to be recognized...
Yeah, you should be recognized. You can understand that I have been patient and listened to people not be recognized and speak anyway, because I would like to have this be a peaceful session.
Well, before I try your patience, I'm done.
Mr. Chairman, I have a question about ground rules.
Go ahead.
The question is, before we can proceed, I'd like to know whether the majority is still requiring of all of the Democratic members of this committee to pre-clear the questions, documents, and videos that we would like to use at this hearing.
I was hoping that on the subject that you just brought up, that we would have some clarification of what you want to approach. that. And I'm not prepared to answer that question because I don't know what the answer has been, and I don't want you to give me what you think the answer has been of discussion between our staff on that subject.
Mr. Chairman, I don't think it's ever been the case in a hearing like this that the members of this committee have to pre-clear what we propose to query the nominee about. I think that is totally unprecedented.
And Mr. Chairman, if we don't even know what the rules are, how can we proceed with this
I'd like to respond to Senator Hirano. The reason why we're having that discussion is, at least in my time on this committee and for 15 nominations, we've never had a request for a video. So it seems to me, to be courteous to all the members of the committee, it'd be nice to know the purpose and what it might contain. Any questions you want to ask, you can ask questions. It isn't about what questions you were going to ask. It's about the presentation of something that's never been a part of a Supreme Court hearing in the past.
Mr. Chairman.
Who wanted?
Mr. Chairman.
Yes. I think I'll go back and forth. Senator Tillis.
Mr. Chairman, I'm confused because I heard earlier that this was a reaction to the document releases last night, but I'm reviewing a tweet from NBC that said Democrats plotted coordinated protest strategy over the holiday weekend, all agreed to disrupt and protest the hearing, sources tell me. And subsequent Dem leader Chuck Schumer led a phone call, and committee members are executing now. So I just want to be clear, none of the members on this committee participated in that phone call or that strategy before the documents were released yesterday. Is this? Are you suggesting that this allegation is false?
This is outrageous.
Senator Durbin.
Mr. Chairman, there was a phone conference yesterday, and I can tell you at the time of the phone conference, many issues were raised. One of the issues was the fact that over 100,000 documents related to Judge Kavanaugh have been characterized by the chairman of the committee as committee confidential. I've been a member of this committee for a number of years. Committee confidential documents have been really limited to extraordinary circumstances. As an example, if someone is accused of taking drugs during the course of an investigation, and I'm not making any suggestion that that is even the case or close to it here, it was done in a confidential setting, in fairness to the nominee. And the same thing on DUIs and the like. We used it in extremely rare circumstances where we would meet after this committee hearing and sit down, and it usually related to a handful of pages or a handful of document references. Instead, what we found now is that we are seeing hundreds of thousands of documents characterized as committee confidential unilaterally. It's not done on a bipartisan basis. It's being done by the chairman. So one of the discussions yesterday was this whole question of whether this committee is going to hear a nominee for a lifetime appointment to the highest court in the land without access to basic information about his public record. His public record as Secretary to the President of the United States, Staff Secretary. 35 months of public service, we've been told, cannot even be considered. The documents of that service cannot even be considered. So I'd say to the gentleman, or the senator from North Carolina, there was a conversation yesterday about these documents. I had no idea that at 11 o'clock last night, 42,000 more documents would be put on top of us, and we'd be asked to take them up today. So it added insult to injury.
Mr. Chairman,
Chairman, I ask to be recognized under Rule 4. Rule 4 states, the chairman shall entertain a non-debatable motion to bring a matter before the committee to a vote. If there is objection to bring the matter to a vote without further debate, a roll call of the committee shall be taken, and debate shall be terminated if the motion to bring the matter to a vote without further debate passes with 11 votes in the affirmative, one of which must be cast by the minority. I ask for a vote on my motion to adjourn under Rule 4, Mr. Chairman. These are rules that we are obligated to follow. The chairman has no right, with all due respect, to simply override them by fiat.
Yeah. We are obligated. We're obligated by that rule in executive session. We're not in executive session. I would respond to the issues brought up by Senator Durbin about confidential documents. I was criticized for my decision to receive some documents on committee confidential. but I'm doing exactly what I did during Judge Gorsuch's confirmation and what Chairman Leahy did during Justice Kagan's. This is another example of treating regular committee practices as somehow out of the ordinary. Presidential records that we receive often contain highly sensitive advice to the president, as well as personal privacy information like full names, date of birth, Social Security numbers, and bank account numbers. Like my predecessor, I agreed to receive some presidential records as committee confidential so that both Democrats and Republicans could begin reviewing Judge Kavanaugh's materials much earlier. I don't know why my Democrat colleagues object to receiving documents faster. But not all of these presidential records remain confidential. In fact, nearly two-thirds already became public. These records are posted on the committee's public website and available to the American people. As a result, we provided unprecedented public access to a record number of presidential records and did it in record time. The most sensitive presidential records remain committee confidential under federal law, just as they were during the nominations of Kagan or Gorsuch. But we have expanded access to these documents also. Instead of just providing access to committee members, we provided access to all 100 senators. Instead of just providing access to a very few committee aides, we provided access to all committee aides. And instead of just providing access to physical binders of paper, we provided 24/7 digital and searchable access. This is unprecedented access to committee confidential material. I'd also like to add that my staff set up workstations and have been available 24/7 to help senators who are not on committee access confidential materials, but not one senator showed up. I guess senators complaining about lack of access to confidential documents weren't really interested in seeing them in the first place. But I want to emphasize more documents are widely available than in any prior Supreme Court nomination. And then to the issue about hiding committee confidential documents. Some colleagues, and you've heard it this morning, accuse of hiding documents. They're suggesting that some of the committee confidential documents contain information that would be of great interest to the public. Well, just as I did last year during Justice Gorsuch's confirmation, I put a process in place that would allow my colleagues to obtain the public release of confidential documents for use during the hearing. All I asked was my colleagues to identify the documents they intended to use, and I would work to get the Department of Justice and former President Bush to agree to waive restrictions on the documents. Senator Feinstein secured the public release of 19 documents last year under this process, and Senator Klobuchar secured the release of 4 documents this year. If my colleagues truly believe that other committee confidential documents should have been made public, they never told me about them and request the ones that they wanted. Instead of scaring the American people by suggesting that we're hiding some incriminating documents, they should have made a request that I work to get the committee confidential designation removed. This year, I received no such request except from Senator Klobuchar, which was honored and resulted in the disclosure of documents that she wanted to use during this hearing.
Mr. Chairman, you stated what I did, and you stated it inaccurately. I think I have the right.
I said I was paraphrasing it.
Well,
you can correct me any way you want.
It was one heck of a paraphrase when you
give me the exact
when you
quote.
speak about doing the same thing as with Elena Kagan. I was chairman when Elena Kagan was here. We had 99% of her records from the White House were made public 12 days before the hearing. With Judge Kavanaugh, we have 7%, and only 4% are public. You can talk about the numbers of pages. The fact is, 99% for Atlantic Hagan, 12 days before the hearing. It was all available. For Judge Kavanaugh, 7%, and only 4% made public. So, if we're going to argue what was precedent, I would point out that I've been in the Senate for 19 Supreme Court nominations. What is being done here is unprecedented. And I keep coming back to the same question I asked. What are we trying to hide? What are we hiding? What's being hidden? Why not have it open like all others? The only other time we heard a president invoke executive privilege was President Reagan during the Justice William Rehnquist hearing, and Republicans and Democrats together went to him and said, don't do that. And he said, okay, you're right. And he withdrew his request of executive privilege and released the documents.
Mr. Chairman.
I'm just sorry to see the Senate Judiciary Committee descend this way. I felt privileged to serve here under both Republican and Democratic leadership for over 40 years. This is not the Senate Judiciary Committee I saw when I came to the U.S. Senate.
Mr. Chairman, since my name was invoked by you, could I please respond?
After I get done, I want to give the exact quote that I was paraphrasing. Chairman Leahy said, quote, "We have Judge Sotomayor's record from the federal bench. That is a public record that we had even before she was designated by the president. Judge Sotomayor's mainstream record of judicial restraint and modesty is the best indication of her judicial philosophy. We do not have to imagine what kind of a judge she will be because we see what kind of a judge she has been." And so that's why my answer to the gold standard of whether Senator Kavanaugh ought to be on the Supreme Court, based upon what Democrats themselves have said is the best judge of whether you should be on the Supreme Court. Senator Klobuchar.
Oh, wait a minute. You mentioned what I said. Let me just finish on that. On Justice Sotomayor, I did say that we should look at her cases just as we should on Judge Kavanaugh's. But you neglect to mention, carefully neglect to mention, and I think erroneously neglect to mention, that the Republicans asked for board minutes from her work at a civil rights group in the 1980s, long before she was ever even considered as a judge. You asked for that, and we got it for you. That's
Mr. Chairman.
Mr. Chairman.
Mr. Chairman, you called on me.
Before Senator Klobuchar speaks, so we have 488,000 pages of documents. Go ahead, Senator Klobuchar.
Thank you very much, Mr. Chairman. Few points here. Number one, Justice Sotomayor never worked in the White House, so none of these issues of executive privilege or other things that we've been discussing are relevant. Number two, while I appreciate you granting my request, Mr. Chairman, on these campaign finance documents, this is all they were. This is it. This is how many pages. Yet we have 148,000 documents that we can't talk about publicly. And I will say they are illuminating. It shows that the nominee has a limited view of campaign finance reform. In his own words, he says that his views on the First Amendment are pure when it comes to this very important issue. And we can talk about that more in the future. But I do have a question, and that is that, yes, I asked for these documents, but I've also joined several letters led by Senator Feinstein asking that all the documents that we have in the committee be made public so that we can ask questions. And then finally, on my initial point that I'm so focused on, the 102,000 pages of documents from Judge Kavanaugh's work in the White House Counsel, I would like to know, Mr. Chairman, if you have another example of a time when executive privilege was invoked to block the release of presidential records to the Senate during a Supreme Court nomination. As far as my research shows, this wasn't done for Justice Kagan or Justice Roberts, and I'd like to know if you have another example of that during a Supreme Court nomination hearing.
Yeah, it was done for Justice Roberts, and it was a Solicitor General's position he had.
When he was a Solicitor General, that is correct, but during the time that they worked in the White House. That is my question.
Mr. Chairman, I'd like to bring you the attention of the Chair.
I believe I have the floor.
Senator Cornyn.
Thank you, Mr. Chairman, for recognizing me. I haven't been in as many confirmation hearings as some of my colleagues, but this is the first confirmation hearing for a Supreme Court justice I've seen basically according to mob rule. We have rules in the Senate. We have norms for decorum. Everybody, as you pointed out, Mr. Chairman, is going to get a chance to have their say.
Yeah.
You've given everybody a chance to ask questions for up to 50 minutes. You've given them a chance to make an opening statement. Any one of our colleagues can step out here and talk to the press and make whatever comments they want to the press and tell the world how they feel about this. But the fact is, it's hard to take it seriously when every single one of our colleagues in the Senate Judiciary Committee on the Democratic side have announced their opposition to this nominee even before today's hearing. So it's hard to take seriously their claim that somehow they can't do their job because they've been denied access to attorney-client or executive privilege documents when they've already made up their mind before the hearing. There's nothing fair about that. And we would just ask for an opportunity for the American people to be able to listen to this nominee answer the questions that we have. And I think that's how we ought to proceed, and I hope we will.
Mr. Chairman, can I be recognized to respond specifically to that comment? There is precedent here. There are rules that can guide us. We're asking for those rules to be followed. In the past, our colleagues on the Republican side have asked for a postponement of these committee proceedings on nominations when documents have been denied on 2 occasions from Senator Sessions, then Senator Sessions, and Senator Kyle. Those requests were granted. We're asking simply that that precedent be followed, Mr. Chairman. Far from mob rule, far from contempt of the process, we're simply asking for respect here to the normal, regular order.
Mr. Chairman.
Yeah, go ahead.
Mr. Chairman, I'd like to address this committee confidential issue one more time because you've explained your point of view. Here's what we know. The Chairman Grassley, who's my friend and I respect, said his reason for unilaterally designating 147,000 pages of Burke documents as committee confidential is because that was the condition that Bill Burke imposed on the provision of the documents. When Judge Kavanaugh was in my office meeting with us, I asked him, who is Bill Burke? By what authority can he restrict the information given to the Senate Judiciary Committee and to the American people? Is he a government employee? No one knew. This mysterious Bill Burke who is filtering these documents. So I figured since the nominee carries the Constitution in his pocket, there must be some reference to Bill Burke in Article 2, Section 2, but it just says advice and consent of the Senate. It doesn't include Mr. Burke. By what authority is this man holding back hundreds of thousands of documents from the American people? Who is he? Who's paying him? So committee confidential is being determined by a man, a private attorney, and we don't know who he works for or who he's accountable to. Mr. Chairman, in the past, when we went into committee confidential, it was in a discrete, specific area of concern involving a handful of words or accusations that had been made in a document, and we were very careful to do it on a bipartisan basis. That has not been the case here, where 147,000 pages have been designated by Bill Burke as outside the reach of the American people in the Senate Judiciary Committee. That's a further example of why this whole process has gone astray. And I think your explanation ignores that.
Mr. Chairman. Mr. Chairman.
Who wants the floor?
The new senator.
Go ahead.
Thank you, Mr. Chairman. Mr. Chairman, can you tell me again how many documents have been produced?
488,000 minus, other than 28,000 pages that Justice Kavanaugh has submitted. including his own judicial opinions.
Number two, are we in executive session or not?
We're having a hearing on the nomination of a nominee for the Supreme Court.
Yes, sir. I got
We're not in executive session.
All right. Number three, at some point, are we going to get to hear from the nominee?
Hopefully, it was going to be before 2:30. It'll probably be later this afternoon now.
All right. Thank you, Mr. Chairman.
Yeah.
Mr. Chairman.
Can I ask my colleagues on the other side of the aisle how long you want to go on with this? Because I'm not going to entertain any of the motions you're making. We're not in an executive session, and I think we ought to level with the American people. Do you want this to go on all day? Because I have been patient. I've been accused of having a mob rule session. Now, if we have a mob rule session, it's because the chairman's not running the committee properly. But since every one of you on that side of the aisle, except Senator Booker, Senator Harris, new to the committee, said during Justice Gorsuch's hearing, every one of you prefaced your comments on how fair I was in running that hearing. Now, this is the same Chuck Grassley that ran the Gorsuch hearings. I'd like to run this hearing the same way if you'll give me the courtesy of doing it.
Thank you, Mr.
How
Chairman.
long do you want to go on?
Mr. Chairman, I'd like to make one more point before we proceed, if I might.
Senator Coons.
The accusation that this is a mob rule hearing was made by your colleague from the state of Texas. I think you have been conducting this in a respectful, appropriate, and deliberate way. My concerns that I want to renew, given the exchange you just had with Senator Leahy, who has participated in or presided over more Supreme Court confirmations than any currently serving member, I believe, was over how the document request was handled for now Justice Kagan. A request was sent to the National Archives. Ranking Member Feinstein tried to work with you to send an identical request to the National Archives. And before we proceed with the questioning, Mr. Chairman, I simply would like to have a settled heart about why you chose to communicate directly to the archives, not to respond to the ranking member's request. Members of this committee have raised issues about an unprecedented committee process by which documents were blocked, by which they were considered classified, and by which we have been blocked from being able to share them with the American people or ask questions based on them. This is unprecedented. That's why, as you put it, this side seeks to raise issues to establish ground rules before we proceed.
You've asked an appropriate question. I have an answer. I don't know whether it will satisfy you or not. Those documents are the least useful in understanding his legal views and the most sensitive to the executive branch. And let me emphasize the most sensitive to the executive branch. The staff secretary serves as an inbox and outbox to the Oval Office. And if you're going to have opportunities to ask the nominee himself what he did then, but I'm giving you my judgment about being a person that primarily was responsible for managing the paper that crosses the president's desk. His job, and if I'm wrong, he can satisfy you otherwise in your questions you wanted to ask him, but his job was to make sure the president sees the advice of other advisors, not as staff secretary providing his own advice. One of President Clinton's staff secretaries, Todd Stern, described the job this way. I quote, "The staff secretary's job is not to influence the president, but to ensure he gets a balanced diet of viewpoints from all relevant people on the staff. You're certainly not trying to put your thumb on the scale between options." Reviewing Judge Kavanaugh's staff secretary documents would teach us nothing about his legal views. For that, we have the 307 opinions that he wrote and the hundreds more joined, totaling more than 10,000 pages of judicial writings. We also have more than 17,000 pages of speeches, articles, teaching materials, and other materials that Judge Kavanaugh attached to his 120-page written response, which I think was a judiciary's questionnaire, was probably the most robust questionnaire ever submitted to a Supreme Court nominee. We also have more than 480,000 pages of emails and other documents from Judge Kavanaugh's service as an executive branch lawyer. This is 500,000 pages of paper, more than the last 5 confirmed Supreme Court nominees combined. In addition to not shedding light on Kavanaugh's legal views, the staff secretary documents are very sensitive to the executive branch. Let's emphasize that word sensitive. These documents contain highly confidential advice, including national security advice, that went directly to the president from his advisors. It would threaten the candor of future advice to presidents if advisors knew their advice would be broadly disclosed. Senators have more documents for Judge Kavanaugh than any nominee in Senate history. Democratic leaders insistent on getting staff documents, I think, was a way of not having this hearing take place at this particular time. So can I proceed, members of the Democratic Caucus?
Mr. Chairman, if I may be recognized for one final
After
point.
you're done, can I proceed to my opening statement?
I'll defer to my colleagues, but just as a point of information, we sent a letter to you, Mr. Chairman, 7 days ago regarding the committee confidential nature of the documents and asked that they would not be designated committee confidential. As another point of information, it is my understanding there are 6 to 7 million pages of documents regarding this nominee. And it is my understanding, with all due respect, Mr. Chairman, that you've only requested 10 to 15% of the total. I appreciate that there are a lot of pages of documents, but we have to have this conversation in the context of the total and the fact that we've only been given, by your request, 10 to 15% of those documents. And my final point is this.
I got it.
This is a hearing about who will sit on the highest court of our land. This is a hearing that is about who will sit in a house that symbolizes our system of justice in this country. And some of the most important principles behind the integrity of our system of justice is that we have due process and we have transparency. That is why we have public courtrooms. That is why we have requirements in courts of law in our country that there will be transparency, that both parties will be given all relevant information. We can argue then as to the weight of the documents and the significance, but not as to whether or not they're admissible. So I object. I ask that we renew and revisit Senator Blumenthal's motion to suspend or my motion to postpone this hearing. Thank you.
Okay. Thank you.
Mr. Chairman.
I appreciate the courtesy of the Democrats for me to proceed.
May I just have one last opportunity?
Please go ahead.
On my motion. Thank
you,
Mr. Chairman.
Please go ahead.
I appreciate your giving me the floor. I've made a motion that is properly before this committee. The chairman said earlier that he has never been through a confirmation process like this one. The reason is that no administration in the past has engaged in this kind of concealment. That's the reason, very simply. It is not the chairman's doing, necessarily. It is this administration that has concealed and hidden documents from us and from the American people. And so I renew my motion that we adjourn so that we can access the documents we need, review them in a deliberate and thoughtful way. Much has been done for colleagues in the past when they have requested it, and as is required under Rule 4 of our rules, there is no requirement that we be in executive session to follow this rule, Mr. Chairman. And I respectfully ask that we follow our rules, that we proceed in accordance with those norms. And I know the chairman has great respect for open government, for whistleblowers, for sunlight as the best disinfectant. We need some sunlight in this process. Thank you, Mr. Chairman. And I again renew my motion to adjourn, which has been seconded by Senator Whitehouse.
Denied because we're not in executive sessions. I will proceed with
Mr. Chairman, before you proceed, I'd just like to make one correction. There is a misconception as to what White House staff secretaries do. And in fact, two past staff secretaries, Todd Stern and John Podesta, wrote an op-ed in July 30, 2018, Washington Post titled, "Staff Secretaries Aren't Traffic Cops. Stop treating Kavanaugh like he was one." And in fact, Judge Kavanaugh himself has acknowledged the importance of the time that he was White House staff secretary. So why, Mr. Chairman, you and the others on your side keep saying that this was a kind of a nothing kind of a job, nothing could be further from the truth. And this is why we are so adamant about requesting these documents that the judge himself, the nominee himself, has said were among the most formative time of his adult life. Thank you, Mr. Chairman.
Of course, that's why we have this hearing. Judge Kavanaugh.
We don't have the documents.
Judge Kavanaugh will have an opportunity to answer every question about his role in almost anything he's done in his lifetime, I assume.
Mr. Chairman. Mr. Chairman, may I be recognized, sir?
Yeah, will you be the last one, or do you want to go on all afternoon?
I can't speak for my colleagues, but a lot of people I have a lot of respect for on this committee, especially some of the new folks. I just want to answer in the most plain-spoken way I can possibly do. We're expected to evaluate a nominee who has a vast record. And if you look, and a lot of numbers have been cited, 10,000 here, 40,000 here, 100,000 here, but in the entire body of his record, sir, we've only have 10% of his record we've been able to evaluate. 90% of it has been withheld from senators, 90% of his record. So we're asking to evaluate a candidate, to have intelligent questions and insights into his record, but we only have 10% of that record. We can go on and on about the numbers of documents, 100,000, 10,000, but the fact is we are about to proceed with a historic hearing. We're about to proceed towards having a hearing on someone having a lifetime appointment on the most important court in the land that will effectuate so many of the areas of American life, from civil rights to women's rights to access to health care. All of this stuff is being decided, and we're going into this only having 10%, access to 10% of the body of work of this man's career. That seems to me just common sense. 90% is missing right now. Just common sense says we should have access to thoroughly evaluate this person. We're not asking for anything out of the ordinary. Other candidates have come before. People can talk about tens of thousands here, 100,000 here, but we've gotten far more for every Supreme Court justice that has been mentioned here, far more than just 10%, just a scan a bit. My colleagues talk about what our duty to the American public is. Our duty to the American public is to evaluate a candidate on their body of work, but we're not even getting released that. And why? Because some political person, not a person who holds public office, not because, I mean, it's unprecedented to think that this committee has ceded its role to a partisan outside lawyer. And so here we're about to go forward with just 10% of this person's record to evaluate, to base our questions on, to investigate. 90% is being withheld. Just common sense would say that that's not fair, that's not right, it undermines our ability to do our job. It is just plain wrong.
One of the Senate's most solemn constitutional duties is to provide advice and consent to the President on the nomination of Supreme Court justices. We're here this week to hear from Brett Kavanaugh, to hear about his exceptional qualifications, his record of dedication to the rule of law, and his demonstrated independence and his appreciation of the importance of the separation of powers. Indeed, to protect individual liberty, the framers designed a government of three co-equal branches, strictly separating legislative, executive, and judicial powers. The framers intended for the judiciary to be immune from the political pressures the other two face. That is, so that judges would decide cases according to the law and not according to popular opinion. Now, 230 years after ratification, our legal system is the envy of the world. It provides our people stability, predictability, protection of our rights, and equal access to justice. But this is only possible when judges are committed to the rule of law. Our legal system's success is built on judges accepting that their role is limited to deciding cases and controversies. A good judge exercises humility and makes decisions according to specific facts of the case and, of course, according to the law. A good judge never bases decisions on his preferred policy preferences. A good judge also has courage, recognizing that we have an independent judiciary to restrain judges when that government exceeds lawful authority. President Andrew Jackson said, quote, "All the rights secured to the citizens under the Constitution are worth nothing and a mere bubble except guaranteed to them by an independent and virtuous judiciary," end of quote. Confirmation hearings for Supreme Court nominees are a very important opportunity to discuss the appropriate role of judges. As I see it, and I expect many of my colleagues will agree, the role of the judge is to apply the law as written, even if the legal result is not one the judge personally likes. Justice Scalia has often been quoted because he was fond of saying, if a judge always likes the outcome of the cases he decides, he is probably doing something wrong. I don't want judges who always reach a liberal result or a conservative result. I want a judge who rules the law the way the law requires. Judges must leave lawmaking to the Congress, the elected representatives of the people. Judges and justices have lifetime appointments. They can't be voted out of office if they legislate. Whereas if Congress legislates something that people don't like, then you can vote them out of office. That's why they're to interpret law and not make law. Now, some have a very different view of what a judge's role should be. According to this view, judges should decide cases based upon particular outcomes in order to advance their politics. But the American people don't want their judges to pick sides before they hear a case. They want a judge who rules based upon what the law commands. This is the reason why all Supreme Court nominees since Ginsburg have declined to offer their personal opinions on the correctness of precedent. Seeking assurances from a nominee on how he will vote in certain cases or how he views certain precedent undermines judicial independence and essentially asks for a promise in exchange for a confirmation vote. It's unfair and unethical. Indeed, what litigant could expect a fair shake if the judge has already prejudged the case before the litigant even enters the courtroom? I expect Judge Kavanaugh, in fact, it's my advice to him, to follow the example set by Justice Ginsburg and all nominees that followed her, that a nominee should offer, quote, no hints, no forecasts, no previews, end of quote, on how they will vote. Justice Kagan, when asked about Roe v. Wade, said the following, quote, I do not believe it would be appropriate for me to comment on the merits of Roe v. Wade other than to say that it is a settled law entitled to precedential weight. The application of Roe to future cases and even its continued validity are issues likely to come before the court in the future, end of quote. senators were satisfied with these answers on precedent. So, senators should be satisfied if Judge Kavanaugh answers similarly. This is my 15th Supreme Court confirmation hearing since I joined the committee in 1981. 31 years ago, during my 4th Supreme Court confirmation hearing, liberal outside groups and their Senate allies engaged in an unprecedented smear campaign against Judge Robert Bork. As Mark Pulliam said in an op-ed over the weekend, quote, "The Borking of Robert Bork taught special interest groups that they could demonize judicial nominees based solely on their worldview. Worse, character assassinations proved an effective tactic, nearly sinking Justice Clarence Thomas's appointment 4 years later." But he also said, continuing to quote, "By confirming Judge Kavanaugh, the Senate can go some way toward atoning for shameful treatment of Justice Robert Bork 31 years ago," end of quote. Judge Kavanaugh is one of the most qualified nominees, if not the most qualified nominee that I've seen. A graduate of Yale Law School, clerking 3 federal judges, including a man he nominated to replace. He spent all but 3 years of his career in public service and has served as a judge for 12 years on the D.C. Circuit, the most influential federal circuit court. He has one of the most impressive records for a lower court judge in the Supreme Court. In at least a dozen separate cases, the Supreme Court adopted positions advanced by Judge Kavanaugh. The American Bar Association, whose assessment Democratic leaders have called the gold standard of judicial evaluations, rated Judge Kavanaugh unanimously well qualified. A review of Judge Kavanaugh's extensive record demonstrates a deep commitment to the rule of law. He has written eloquently that both judges and federal agencies are bound by the law Congress enacts. And he's criticized those who substitute their own judgment about what a statute should say for what the statute actually says. After President nominated Judge Kavanaugh, I said this would be the most thorough and transparent confirmation process in history. I say that statement even regarding all the discussion we've had this morning. It has proven to be, from Judge Kavanaugh's authoring 307 opinions, joined hundreds more, amounting to more than 10,000 pages. He submitted 17,000 pages of speeches, articles, and other materials to the committee, along with this 120-page written response to the questionnaire that the committee set out. These adds up to 27,000 pages of Judge Kavanaugh's record already available to the American people, and we received just shy of 500,000 pages of emails and other documents from Judge Kavanaugh's service as an executive branch lawyer, which is more than we received for the last 5 Supreme Court nominees. Every one of these more than 483 pages of executive branch records are available to any senator 24/7. I push for federal officials to significantly expedite public disclosure process under federal law so that all Americans have online access to more than 290,000 pages of these records right now on our committee website. In short, the American people have unprecedented access and more materials to review Judge Kavanaugh than ever have had for a Supreme Court nominee. And to support the review of Judge Kavanaugh's historic volume of material, I've worked to ensure that more senators have access to more material than ever. Since so much of the rest of my statement has been discussed this morning by what the Democrats have said, and I've answered a lot of it, I'm going to put the last 7 pages of my statement in the record, and I'm going to ask Senator Feinstein if she has more to say on her opening statement. And if she doesn't, I'll go to Senator Hatch. Or do you have
Thank
some?
you. I do, Mr. Chairman. I will probably truncate it even so. But I think it's really important that people, as well as the judge, the nominee, understand how strongly we feel and why we feel that way. I want to talk a little bit about one of the big decisions that we have the belief that, although you told Senator Collins that you believed it was settled law, the question is really, do you believe that it's correct law? And that's Roe v. Wade. I was in the 50s and 60s active, but first as a student at Stanford. I saw what happened to young women who became pregnant. And then subsequently, I sat as a appointee of Governor Brown's on the term setting and paroling authority for women in California who had committed felonies. And so I sentenced women who had committed abortions to state prison and granted them paroles. And so came to see both sides, the terrible side and the human and vulnerable side. And when you look at the statistics during those days, those statistics that the Guttmacher Institute has put out are really horrendous. For you, the president that nominated you has said, I will nominate someone who is anti-choice and pro-gun. And we believe what he said. We cannot find the documents that absolve from that conclusion. So what women have won through Roe and a host of privacy cases, to be able to control their own reproductive system, to have basic privacy rights, really extraordinarily important to this side of the aisle. And I hope the other side of the aisle as well. Last year, you drafted a dissent in Garza v. Hargan. And that's a case where a young woman in Texas, I believe, was seeking an abortion. In that dissent, you argued that even though the young woman had complied with the Texas parental notification law and secured an approval from a judge, she should nonetheless be barred. In making your argument, you ignored and, I believe, mischaracterized a Supreme Court precedent. You reasoned that Jane Doe should not be unable to exercise her right to choose because she did not have family and friends to make her decision. The argument rewrites Supreme Court precedent, and if adopted, we believe would require courts to determine whether a young woman had a sufficient support network when making her decision, even in cases where she has gone to court. This reason, I believe, demonstrates that you are willing to disregard precedent. And if that's the case, because just saying something settled law, it really is it correct law? The impact of overturning Roe is much broader than a woman's right to choose. It's about protecting the most personal decisions we all make from government intrusion. Roe is one in a series of cases that upheld an individual's right to decide who to marry. It's not the government's right. Where to send your children to school, the government can't get involved. What kind of medical care you can receive at the end of life, as well as whether and when to have a family. And I deeply believe that all these cases serve as a bulwark of privacy rights that protect all Americans from over-involvement of the government in their lives. And to me, that's extraordinarily important. Next, I'd like to address the President's promise to appoint a nominee blessed by the NRA. In reviewing your judicial opinions and documents, it's pretty clear that your views, and I'd like to straighten that out. It's my understanding that during a lecture at Notre Dame Law School, you said you would be the, quote, first to acknowledge that most other lower judges, court judges, have disagreed with your views on the Second Amendment. For example, in District of Columbia v. Heller, you wrote that unless guns were regulated either at the time of the Constitution was written or traditionally throughout history, they cannot be regulated now. In your own words, gun laws are unconstitutional unless they are, quote, traditional or common in the United States. You noted that banning assault weapons is unconstitutional because they have not historically been banned. And this logic means that even as weapons become more advanced and more dangerous, they cannot be regulated. Judge Easterbrook, as you know, a conservative judge from the Seventh Circuit, concluded that that reasoning was absurd, and he pointed out that a law's existence can't be the source of its own constitutional validity. In fact, I'm left with the fact that your reasoning is far outside the mainstream of legal thought, and that it surpasses the views of Justice Scalia, who was clearly a pro-gun justice. Even Scalia understood that weapons that are like M16 rifles or weapons that are most useful in military service can, in fact, be regulated. And there's no question that assault weapons, like the AR-15, were specifically designed to be like the M16. The United States makes up 4% of the worldwide population, but we own 42% of the world's guns. Since 2012, when 20 first graders and 6 school employees were killed at Sandy Hook Elementary, there have been 273 school shootings. This is an average of 5 shootings every month and a total of 462 children, teenagers, teachers, and staff shot and 152 killed. I care a lot about this. I authored the assault weapons legislation that became law for 10 years, and I've seen the destruction. If the Supreme Court were to adopt your reasoning, I fear the number of victims would continue to grow and citizens would be rendered powerless in enacting sensible gun laws. So this is a big part of my very honest concern. You're being nominated for a pivotal seat. It would likely be the deciding vote on fundamental issues. So during your time in the White House, when you were staff secretary, some people regard it as kind of a monitoring things going in and going out. But I think it's much more. And you yourself have said that that's the period of my greatest growth. And so we try to look at it. And the only way we can look at it is to understand the documents. And it's very, very difficult. I don't want to take too much time, but we've heard a lot of noise. Behind the noise is really a very sincere belief that it is so important to keep in this country, which is multi-ethnic, multi-religious, multi-economic, a court that really serves the people and serves this great democracy. And that's my worry. That's my worry. So I look forward to your statement and answering the questions. Thank you, Mr. Chairman.
Senator Hatch for 10 minutes.
Well, thank you, Mr. Chairman. I'd first like to thank you for your tremendous work in organizing this hearing. This has been the most thorough Supreme Court confirmation process that I've ever participated in. We've received more than twice as many documents for Judge Kavanaugh was for any Supreme Court nominee in history. This is a big deal. We have tens of thousands of pages of Judge Kavanaugh's opinions, speeches, and other writings. This has been an exhaustive process, and I want to thank you for your leadership on it. Now to our witness, Judge Kavanaugh, it's good to see you. I've known you for a long time. This is my 15th and final Supreme Court confirmation hearing. I participated in the confirmation of every current justice on the court. I've participated in the confirmation of over half of all federal judges now serving in the federal system, or who have ever served in the federal system. I know a good nominee when I see one, and you are a great nominee. I don't think there's any question about it. I've known you for a long time. I remember when you first came before this committee, back in 2004 for your first confirmation hearing. I was the chairman of this committee at the time. I got to know you well. I was impressed by your intellect, your legal ability, and your integrity, all of which were very much notable. At only 39 years of age, you knew more about the law than most lawyers who have practiced for a lifetime. And you have been an outstanding judge. You have earned the respect of your colleagues. And you've learned the respect of the Supreme Court as well. As you know, the Supreme Court has adopted the positions in your opinions no less than 13 times. That's something nobody can really argue against. You've authored landmark opinions on the separation of powers, administrative law, and national security. You served as a mentor to dozens of clerks and hundreds of law students, male and female. Your student, and some of whom did not share your philosophy. Your student reviews are off the charts favorable, even by those who may not have completely agreed with your philosophical approaches on some matters. You volunteer in your community. Mr. Chairman, I ask for order.
Yeah, just go ahead.
Okay, you volunteer in the community. You coach youth basketball. You're the sort of person many of us would like to have as a friend and a colleague. You also apparently like to eat pasta with ketchup. But nobody's perfect. Now, this being politics and this being a Supreme Court confirmation hearing, my Democratic colleagues actually I've got to admit this is my Democratic colleagues can admit that you're actually a good judge and a good person as well. They have to turn the volume up to 11 and try to paint you as one of the four horsemen of the apocalypse. Anyone who actually knows you knows that's ridiculous. And the American people will see soon enough that you are a smart, decent, normal person who just so happens to have been nominated to the highest court in our land. So here are the facts. Judge Kavanaugh is one of the most distinguished judges. Mr. Chairman, I think we ought to have this loudmouth removed. I mean, we shouldn't have to put up with this kind of stuff. I hope she's not a law student.
Now that we have quiet, I'd like to explain that I advised 2 years ago that at my hearings, I expected the police to do their job, and I expected the committee to go on. But if you don't want to continue...
I'm going to continue.
Okay, go ahead.
Okay, so here are the facts. Judge Kavanaugh is one of the most distinguished judges in the entire country. He has served for over 12 years now in the U.S. Court of Appeals for the D.C. Circuit. The D.C. Circuit is often referred to as the second highest court in the land because it hears many critically important cases involving agency action and the separation of powers. During his time on the bench, Judge Kavanaugh has heard over 1,000 cases. He's written more than 300 opinions. His opinions span nearly 5,000 pages in length. But what's remarkable about Judge Kavanaugh's judicial record is not just its length, but its depth and its quality. Judge Kavanaugh has been a true thought leader. He's written powerful opinions on the separation of powers and administrative law. He's shown that he brings a fair-minded approach to questions of criminal law and employment law. On almost every issue of consequence, Judge Kavanaugh has made a significant contribution to our nation's jurisprudence, and he's won respect from both sides of the political spectrum. The committee has received letters from former clerks, former colleagues, former students, and former classmates, all attesting to Judge Kavanaugh's sterling character and qualifications, some of whom are Democrats. Eminent members of the Supreme Court bar and legal academia have all written in strong support of Judge Kavanaugh's nomination. The authors of these letters emphasize that they have different political views and that they do not agree on every subject. But to a person, they speak of Judge Kavanaugh's integrity and judgment, and they enthusiastically endorse his nomination. I'd like to highlight one letter in particular from 18 of Judge Kavanaugh's former women law clerks. That's all of his former women clerks, all of them, who were not precluded by their current or pending employment from signing the letter. They write that, quote, Judge Kavanaugh has been one of the strongest advocates in the federal judiciary for women lawyers, unquote. They detail the mentoring and encouragement Judge Kavanaugh has given them in their careers. And they say that it is, quote, not an exaggeration to say that we would not be the professors, prosecutors, public officials, and appellate advocates we are today without his enthusiastic encouragement and unwavering support, unquote. It bears emphasis that these former clerks span the political divide. A number went on to clerk for liberal justices. That itself shows you the high regard Judge Kavanaugh has across the ideological spectrum. Republican and Democratic appointed judges alike have hired his former clerks. Judge Kavanaugh is no ideologue. He is no extremist. He is a highly respected, thoughtful, fair-minded judge who is well within the judicial mainstream. Look no further than the letter the committee received from over 40 members of the Supreme Court bar supporting Judge Kavanaugh's nomination. Among the signers are people like Lisa Blatt, Deanne Maynard, and Kathleen Sullivan. These are nationally renowned attorneys who practice frequently before the Supreme Court and the federal courts of appeals, and they are not conservatives. To the contrary, they are among the most prominent liberal attorneys at the bar today and in the country. But they know Judge Kavanaugh. They know his work. They know his character. They know that he is an outstanding judge, and they know that he will make an outstanding justice. If we could just get the politics out of this, I think we could all agree that Judge Kavanaugh is an indisputably qualified nominee with strong backing in the legal community who is well within the judicial mainstream. Go ask anyone who practices regularly before the Supreme Court who doesn't have a partisan agenda, and they'll tell you Judge Kavanaugh is exactly the kind of person we should have on the court, or we should want on the court. Indeed, no less than Bob Bennett, Bill Clinton's personal lawyer during Clinton's presidency, wrote to the committee urging support for Judge Kavanaugh's nomination. Here's what he intended to say, quote, as a Washington attorney, I can attest to the high esteem in which the bar holds Judge Kavanaugh. Lawyers love arguing before him for good reason, because they know he will approach every case with an open mind, unquote. Bennett continues, quote, Brett is the most qualified person any Republican president could possibly have nominated. Were the Senate to fail to confirm Brett, it would not only mean passing up the opportunity to confirm a great jurist, but would also undermine civility in politics twice over. Just in playing politics with such an obviously qualified candidate, and then again in losing the opportunity to put such a strong advocate for decency and civility on our nation's highest court, unquote. Again, this is President Clinton's personal lawyer during Clinton's presidency. who litigated against Judge Kavanaugh. Those who know Judge Kavanaugh hold him in highest regard. This is true of both Republicans and Democrats. Unfortunately, we have all these interest groups screaming from the sidelines and putting pressure on my Democratic colleagues to make this hearing about politics, to make it about pretty much anything except Judge Kavanaugh and his qualifications. We have folks who want to run for president, who want their moment in the spotlight, who want that coveted TV clip. Frankly, I wish we could drop all the nonsense. Judge Kavanaugh is unquestionably qualified. He's one of the most widely respected judges in the country. He's well within the judicial mainstream. Anyone who wants to argue otherwise wants to banish half the country from the mainstream. So, Judge, I'm glad you're here today. I'm sorry you're going to have to go through some of this nonsense that's about to come your way, but I hope you do it well. You're smart. You're smart, and you're a fundamentally decent, good person. Anyone who actually knows you knows that to be true. Now, Mr. Chairman, I don't know that the committee should have to put up with this type of insolence that's going on in this room today. And frankly, these people are so out of line, they shouldn't even be allowed in the doggone room. But Judge Kavanaugh, I'm proud of you. I know how good you are. I know you deserve this position. I'm proud of the president for nominating you. And frankly, I wish you the best because we're going to confirm you.
Out of courtesy to Ranking Member Feinstein, she wants to introduce people who are in the audience. And so she can take what time she wants right now.
Thank you. I'll be very fast. I'd like to recognize Mark Morial, the president of the National Urban League, Melanie Campbell, the president and CEO of the National Coalition on Black Civic Participation, Reverend Al Sharpton, the president of National Action Network, Vanita Gupta, president and CEO, Leadership Conference of Civil and Human Rights, Derek Johnson, President and CEO, NAACP, Sherilyn Ifill, President, NAACP Legal Defense Fund, Kristen Clark, President and Executive Director, Lawyers Committee for Civil Rights, and Fatima Gross-Graves, President and CEO, National Women's Law Center. I would also like to recognize Fred Guttenberg, the father of Jamie, one of 17 killed in the Parkland shooting, Kelly Gregory, former Airman First Class, single mother, business owner, living with stage 4 metastatic breast cancer. Sarah McBride, an advocate for LGBT rights and protections for patients. Tia Nellis, who works on behalf of people with disabilities. Angel Young, an enrolled member of the Standing Rock Lakota and a veteran. Kim Jorgensen Gain, who advocates for a woman's right to choose. Bobby Jenkins, a longtime resident of Randolph County, Georgia, and a voting rights advocate. Carrie Chin, who's been fighting for marriage benefits for same-sex couples, and Carlota Lanier, a member of Little Rock 9. Thank you for this courtesy. I really appreciate it.
Senator Leahy.
Oh, thank you, Mr. Chairman. And I was perfectly happy to yield to Senator Feinstein for that. Mr. Chairman, the last few minutes we've heard a lot of rhetoric. I think it might serve the committee well to have some reality. I've served in the Senate for 44 years. During that span, I've been able to vote on 19 nominations to the Supreme Court. I mention this because I have a sense of history. And I've never seen in that 44 years so much at stake with a single seat. But I've also never seen such a dangerous rush to fill it. President Trump promised he would only nominate judges to the Supreme Court who would overturn Roe versus Wade, judges who would dismantle the Affordable Care Act, judges who would reshape our judiciary. Now, if that's not judicial activism, I don't know what is. And Judge Kavanaugh, with your nomination, the The President has made it very clear that he's following through on his promises, and many of us feel he is. It seems that you may have intrigued him for another reason: your expansive view of executive power and executive immunity. You've taken the unorthodox position that presidents should not be burdened with a criminal or civil investigation while in office. This is now we have a president who has declared in the last 24 hours that the Department of Justice shouldn't prosecute Republicans. You know, it's Alice in Wonderland. And I find it difficult to imagine that your views on this subject escape the attention of President Trump, who seems increasingly fixated on his own ballooning legal jeopardy. When questioning you about these concerns, we'll certainly look to your record on the bench. All of us, Republicans and Democrats, agree that we should. Indeed, your 12 years on the D.C. Circuit Court of Appeals will loom large during these hearings. But the unknown looms even larger. Before sitting on the bench, you were a political operative involved in the most political and partisan controversies of our time. During this time, you shared your personal view on contentious issues without regard to restrictions imposed by precedent or stare decisis. And it's precisely those views that are being hidden from us today. The Judiciary Committee's Supreme Court hearings are meant to be an unsparing examination of a nominee to a lifetime appointment to our highest court. They are intended to give the American people, all the American people, a genuine opportunity to scrutinize a nominee's judicial philosophy, beliefs, and character. Because if confirmed with a stroke of a pen, a nominee may impact their lives for a generation or more. And how far have we fallen? Judge Kavanaugh, there are so many things wrong with this committee's vetting of your record, it's hard to know where to begin. I've been on this committee under both Republican and Democratic leadership. I never thought the committee would sink to this. In fact, you shouldn't be sitting in front of us today. You should be sitting in front of us only after we've completed a review of your record. Your vetting is less than 10% complete. In critical ways, our committee is abandoning its tradition of exhaustively vetting Supreme Court nominees. First, inexplicably, our Republican friends refused to request records from your 3 years as White House staff secretary, even though you described those as the most formative for you as a judge, when you provide advice on any issue that may cross the president's desk. Now, we know those issues include abortion, same-sex marriage, and torture. But 6 weeks ago, Senate Republicans huddled in a private meeting with the White House counsel, who's here today, and hours later, the American people were told those records would be off limits. And second, in a stark departure from committee precedent, certainly the committee precedent I've seen for 44 years, Chairman Grassley sent a partisan record to request to the National Archives. Not only did it omit all 1 million records from your 3 years as staff secretary, it did not even request a privilege log. That means this committee is in the dark as to what specific documents are being withheld and why. We don't even know what is being hidden. Such a move is simply incompatible with transparency. And third, the archives told us they could not even produce this partial records request until the end of October. That's the nonpartisan archives. Surely I would... Mr. Chairman, I do not intend at any point to continue what I have to say with such interruptions. I don't care whose side they're on. Now, the archives have said they could not produce this partial records request at the end of October. Surely I would think that the United States Senate could wait until then, even if it means a Supreme Court with 8 justices for a short time. After all, Senate Republicans established a tradition of having just 8 judges, eight justices. They did that with their treatment of Chief Judge Merrick Garland. That showed they were willing to have patience with filling Supreme Court vacancies when the first time ever they refused to have a vote on a Supreme Court nominee either up or down during a presidential election year. And I've been here when they have had, in the past, such votes. But Republicans instead cast aside the archives. They swapped the nonpartisan review process used for every nominee since Watergate for a partisan one. And I think you only have to look at Watergate to see why we have that nonpartisan process. It's followed by every nomination since Watergate until today. And my question still recurs, what is being hidden and why? Every White House record that we've received was handpicked by your deputy in the Bush White House. A hyper-conflicted lawyer who also represents a half-dozen Trump administration officials who are under investigation by prosecutors in the Russian investigation. And this partisan lawyer decided which of your records the Senate, but more importantly, the American people get to see. And fourth, countless documents that have been provided to the committee contain apparent alterations and omissions with zero explanation. No court in this country, certainly no court that I ever argued cases before, would accept this as a legitimate document production. And the United States Senate shouldn't either. And fifth, more than 40% of the documents we have received, almost 190,000 pages, are considered committee confidential by Chairman Grassley. For the vast majority of them, there's not even a conceivable argument to restrict them. Compare this to the mere 860 documents that were designated committee confidential for Justice Kagan, and that the request was made by the nonpartisan archives, not by this committee. And we still had 99% of her records. And sixth, on Friday, we learned that President Trump is claiming executive privilege over an additional 102,000 pages of your records. Such a blanket assertion of executive privilege is simply unheard of in the history of this country. And the reason it's unheard of is because it is so outrageous. The last time a president attempted to hide a Supreme Court nominee's records by invoking executive privilege was when President Reagan did this for Justice William Rehnquist. But then Republicans and Democrats came together. We demanded the documents be released. And President Reagan said, okay, and they were released. Boy, how times have changed. And seventh to date, we've received less than half of Chairman Grassley's partial records request, meaning we're moving forward even though we've received a fraction of the records. Even Republicans claimed they needed to vet your nomination just a few weeks ago. And then we received an additional 42,000 pages from your record a few hours ago. The notion that anyone here has properly reviewed them or even seen them at all is laughable. It's laughable. It doesn't pass the giggle test. That alone would be reason to postpone during normal times. But nothing about this is normal. All told, only 4% of your White House record has been shared with the public. Only 7% has been made available to this committee. The rest remains hidden from scrutiny. Compare this to the 99% of Justice Kagan's White House record that was available to all Americans. As a result of the bipartisan process I ran within ranking member Jeff Sessions, when Senator Sessions and I requested him, and we got 99%. What is being hidden and why? And if I've not been clear, I will be so now. Today, the Senate is not simply phoning in our vetting obligation, we're discarding it. It's not only shameful, it's a sham. I felt on the day when I took my oath of office the first time, 44 years ago, I was told by both the Republican and Democratic leadership of the Senate, people I highly respected, that the Senate should be and can be the conscience of the nation. I've represented Vermont here for 44 years. I've served with pride here, believing that the Senate can be and should be the conscience of the nation. Today, with this hearing, it is not being the conscience of the nation. And from the bits and pieces of your record we've received, it appears you provided misleading testimony about your involvement in controversial issues at the Bush White House during your previous confirmation hearings. Misleading testimony. I asked you about these concerns last month, and I want to alert you that I will return to those concerns when you are under oath and I'm asking you questions. What I fear is the American people will not know the full truth until your full record is public, and unfortunately, Republicans have done their best to ensure that won't happen. So we begin these hearings with gaping holes spanning multiple years of your career, that deeply influenced by your own words, your thinking as a judge. And any claim that this has been a thorough, transparent process is downright Orwellian. This is the most incomplete, most partisan, least transparent vetting for any Supreme Court nominee I have ever seen. And I've seen more of those than any person serving in the Senate today. So, Judge Kavanaugh, if this hearing is premature, I hope you will use it, though, to answer our questions directly, clearly, and honestly. Because the American people have real concerns about how your confirmation will affect their lives. And I'll conclude with this. The Supreme Court is a guarantor of our liberties in our republic. Few, I would argue, are worthy of taking a seat. Only those with unimpeachable integrity. Only those who believe that truth is more important than party. Only those who are committed to upholding the rights of all Americans, not just those in power. As you know, inscribed in Vermont marble, above the court's entrance are the words, equal justice under law. For the millions of Americans fearful that they're on the verge of losing hard-fought rights, that aspiration has never been more important than it is today. Frankly, as a member of the Supreme Court Bar and as a United States Senator, I feel it's never been more at risk. Thank you.
Before I call on Senator Cornyn, how ridiculous it is to say that we don't have the records that it takes to determine this person qualified to be on the Supreme Court when all the documents we have add up to more than we have had for the last 5 Supreme Court nominees. How do we make those decisions for those other 5?
Mr. Chairman,
Senator Cornyn.
Mr. Chairman, if I could just respond to that point, because you're not giving the whole picture, sir. 90% of the documents we haven't seen. It's not the number of documents.
And I'll be glad to respond to that. But
we wouldn't hire an intern, sir, with only 90% of their resume. We're putting somebody on the Supreme Court.
Senator Cornyn.
Thank you, Mr. Chairman. Judge Kavanaugh, welcome to you and your family and friends. I'm amazed at the poker faces I've seen on the front row during all of this pandemonium, unlike anything I've seen before in a confirmation hearing. In my view, it's not because your opponents don't know enough about you. It's because they do know all they need to know, apparently, to oppose your nomination. And even before you've had a chance to answer our questions, including their questions, many of them have made up their minds, but the American people have not been introduced to you before. This is an opportunity for all of us to engage in a question and answer format that will hopefully illuminate why it is so important to have judges who actually are tethered to the text of the laws passed by Congress, signed by the President, as well as the Constitution of the United States. The Senate Judiciary Committee undertakes few more important tasks than the one before us today. Last year, the committee considered and advanced the nomination of Justice Neil Gorsuch, who was just one of many outstanding judicial nominees by President Trump. This Congress has proudly confirmed not just Judge Gorsuch, but 26 judges to the appellate courts across the nation. This includes 3 outstanding Texans to the Fifth Circuit Court of Appeals. Historically, the confirmation of judges to our highest courts was somewhat routine. Justice Gorsuch was unanimously confirmed by a simple voice vote to the Court of Appeals. Not one senator voted against Justice Kennedy, who both you and Justice Gorsuch clerked for, and who you will succeed on the court. Not one senator voted against Justice Scalia's confirmation, who you have called a role model and a hero. But that was before judges were viewed as policymakers rather than fair and neutral interpreters of the Constitution and the laws drafted by Congress. Today, as I suggested, is a wonderful opportunity to re-examine the proper role for judges under our Constitution and the difference between legislators and judges. As Justice Gorsuch wrote before he joined the Supreme Court, upholding and enforcing this distinction between legislators and judges was the great project of the late Justice Scalia's career. Justice Scalia would always remind us that legislators may appeal to their own moral convictions and to claims about social utility, but judges instead should strive to apply the law as it is, looking to the text, structure, and history, not to decide cases based on their own moral convictions or the policy consequences. So this hearing is an outstanding way to remind the American people of the proper role of judges under our Constitution. Our Constitution provides for a federal government of limited and delegated powers with a Bill of Rights to further protect our individual liberties. To that end, the framers created 3 co-equal branches, as you know: the legislature to enact laws, the executive to enforce them, and the judicial branch to settle disputes about the meaning of those laws and the Constitution. Of course, the legislature could change the laws, but only an amendment can change the Constitution. For this reason, Alexander Hamilton wrote in the Federalist Papers. Mr. Chairman, could I pause there until the room is cleared?
Yeah.
Thank you. For this reason, Alexander Hamilton wrote in the Federalist Papers that the judiciary will always be the least dangerous branch because, as he famously wrote, judges would have neither force nor will, but merely judgment. Today, the Judiciary Committee is gathered to consider whether Judge Kavanaugh will honor that limited role for judges under our Constitution and whether he will properly exercise the modest and humble power of judgment entrusted to him under our Constitution. I'm confident the Senate will find that Judge Kavanaugh will faithfully and fairly interpret the Constitution and the laws of this great nation, and I look forward to him succeeding Justice Kennedy. One reason for that is because I've been acquainted with Judge Kavanaugh for about 18 years, and I can personally attest to his skills as a lawyer. When I was Attorney General of Texas, as the judge will recall, he helped me get ready for a Supreme Court argument. May I proceed, Mr. Chairman?
Yeah.
As I was saying, when I was Attorney General of Texas, I had a chance to argue a couple of cases in front of the United States Supreme Court. One case Judge Kavanaugh helped me prepare for was one involving the question of school prayer at a high school football game at the Santa Fe Independent School District High School. After that, I was pleased to introduce Judge Kavanaugh to the Judiciary Committee when President Bush first nominated him to be a judge on the D.C. Circuit. What I said back then still stands the test of time today. Judge Kavanaugh has an unparalleled academic and professional record of service. Many will cite his education, his clerkships, his time arguing cases before the court, his experience working for the executive branch. But I think one of the most important factors to me is he's already exercised excellent judgment in marrying a Texan, Ashley, from Abilene. So I know he's a good judge. In fact, Judge Kavanaugh is one of the most respected and thoughtful judges in the country. I am disappointed that despite his exemplary qualifications and outstanding record, so many of our colleagues across the aisle have announced their opposition even before he was nominated. The level of disingenuousness and hyperbole, even by today's standards, is extraordinary. Members from the other side of the aisle, including some who serve on this committee, have claimed that confirming Judge Kavanaugh would somehow be complicit in evil and the result in the destruction of the Constitution. Some have even claimed that you testified falsely. We've already heard that alluded to before the committee when you were serving our country in the Bush White House. I hope you'll have a chance to explain the apparent misunderstanding on the part of some senators. And I sincerely hope this week we can all take a deep breath. We're not doing very well so far. And get a grip and treat this process with the respect and gravity it demands. As others have alluded, the American Bar Association, which some have called the gold standard for judicial evaluations, have unanimously rated you as well qualified for service on the Supreme Court. And as we've heard, a number of lawyers and judges across the spectrum have talked about your qualifications and sung your praises. And I'm confident at the end of this hearing, your stellar credentials and your body of work as a judge will demonstrate that you properly understand the role of a judge under the Constitution. And I'm confident you will demonstrate that you will faithfully and fairly interpret the text of the law and the Constitution and dutifully apply them to the disputes that come before you. Finally, Judge, I expect we'll have a conversation or two about this book, which you contributed to, and the law of judicial precedent, because I know that there's a number of questions by members of the Senate about how you will regard previously decided cases in the Supreme Court. And I trust you'll give us a scholarly and detailed explanation of that and demonstrate that many of the concerns that have been expressed about a new justice coming on the court somehow wiping away previous decisions single-handedly, not even with the help of other members of the court, is just plain ridiculous. And we look forward to asking those questions and getting your answer. Thank you very much.
Senator Durbin.
Thank you, Mr. Chairman. Judge Kavanaugh, it's good to see you again. I thank the members of your family who are weathering this hearing. Thank you very much for being here today. This is a different hearing for the Supreme Court than I've ever been through. It's different in what's happened in this room just this morning. What we've heard is the noise of democracy. This is what happens in a free country when people can stand up and speak and not be jailed, imprisoned, tortured, or killed because of it. It is not mob rule. There have been times when it is uncomfortable. I'm sure it was for your children. I hope you can explain this to them at some point. But it does represent what we are about in this democracy. Why is this happening for the first time in the history of this committee? I think we need to be honest about why it's happening. I think it's the same reason why when I go home to Illinois after being in this public service job for over 30 years, I hear a question that I've never, ever heard before, repeatedly. as people pull me off to the side and say, Senator, are we going to be all right? Is America going to be all right? They're genuinely concerned about the future of this country. You come to this moment of history in a rare situation. You are aspiring to be the most decisive vote on the Supreme Court on critical issues. Justice Kennedy did that for 12 years. And you are called to that responsibility. And we realize the gravity of that opportunity and that responsibility. Secondly, of course, your record and the statements of others suggest there's real, genuine concern about changing life and death values in this country because you see things differently. We've heard that over and over again, and I think you must understand the depth of feeling about that possibility. And third, try as they might, I'm afraid the majority just can't get beyond the fact that there are parts of your public life that they want to conceal. They don't want America to see them. I think that's a serious mistake, and I'm going to make a suggestion at the end of my remarks. But over and above all of those things is this. You are the nominee of President Donald John Trump. This is a president who's shown us consistently that he is contemptuous of the rule of law. He has said and done things as president which we've never seen before in our history. He has dismissed the head of the Federal Bureau of Investigation when he wouldn't bend to his will. He harasses and threatens his own attorney general on almost a daily basis in the exercise of his office. And I didn't vote for Jeff Sessions. But I have to tell you, there should be some respect, at least for the office that he serves in. And it's that president who's decided you are his man. You're the person he wants on the Supreme Court. You are his personal choice. So are people nervous about this? Are they concerned about it? Of course they are. I'm sure there'll be a shower of tweets sometime later in the day, harassing people in the cabinet, people in the White House, maybe even dismissing them. And maybe he'll go after me again, be my guest. But the point I'm getting to is if you wonder why this reaction is taking place, it's because what's happening in this country. There are many of us who are concerned about the future of this country and the future of democracy. And you are asking for a lifetime appointment to the highest court in the land where you will make decisions, the deciding vote on things that will decide the course of history and where we are headed. The Senate has a constitutional responsibility to evaluate your nomination. We do know that before you became a judge, you were faithfully advancing the Republican Party agenda. I jokingly said in one of your previous appearances that you're like the Forrest Gump of Republican politics. You always show up in the picture. Whether it's the Ken Starr investigation, Bush versus Gore, the Bush White House, you've been there. We also know that before naming you, President Trump made it clear that he would appoint justices, only appoint justices to the Supreme Court who would overturn Roe versus Wade and the Affordable Care Act. Those were his litmus tests. Now, he didn't ask you the question. What he did was to delegate this responsibility to two special interest groups, the Federalist Society and the Heritage Foundation, and the other groups that are spending millions of dollars in support of your candidacy. They're confident that you're going to favor the interests of corporations over workers and give the president wide berth when it comes to executive authority. And your own law clerks, men and women you chose, men and women who wrote the words that had your signature at the bottom of the page, have told us what they think of you. One wrote in an article entitled, quote, Brett Kavanaugh said Obamacare was unprecedented and unlawful. That's from one of your clerks. Another wrote, when it comes to, quote, enforcing restrictions on abortion, no court of appeals judge in the nation has a stronger, more consistent record than Judge Brett Kavanaugh. Big corporate interests solidly behind your nomination. Chamber of Commerce, full support. And President Trump's, whose lawyers say they will fight any effort to subpoena or indict him all the way to the Supreme Court, that president seems personally eager to have you confirmed as quickly as possible. Why are your supporters so confident you will rule on these issues as they wish? Why do they think you're such a sure bet to take their side when, in the words of one of your former clerks, this is no time for a gamble? Unfortunately, I don't think you're going to tell us much this week. It's interesting to me that people in your position write all these law review articles, make all these speeches, and come to this room and clam up. Don't want to talk about any issues, but that's what I expect. Instead, we'll be asked to trust that if you're confirmed, you'll have an open mind, that you'll follow the law rather than move the law in your direction of your views. I'd like to trust you, but I agree with President Ronald Reagan. Trust, but verify. I wanted to trust you the last time you testified before this committee in 2006, but after you were confirmed at the D.C. Circuit, reports surfaced that contradicted your sworn testimony before this committee. You said to me unambiguously, under oath, the following: I was not involved and am not involved in the questions about the rules governing detention of combatants. But later, just a week or so ago, you acknowledged in my office that you were involved. For 12 years, you could have apologized and corrected this record, but you never did. Instead, you and your supporters have argued we should ignore that simple declarative sentence which you spoke and somehow conclude your words mean something far different. You are a committed textualist, Judge Kavanaugh. If you're going to hold others accountable for their words, you should be held accountable for your own words. So after my personal experience, I start these hearings with a question about your credibility as a witness. I know from my history with you that things you said need to be carefully verified. And that brings us to a major problem. I won't retread the ground about all the documents that are being withheld, but I'll show you a little calendar here that's interesting. There's a 35-month black hole in your White House career where we've been denied access to any and all documents. 35 months in the White House. And I asked you in my office, during that period of time, President Bush was considering same-sex marriage, an amendment to ban it, abortion, executive power, detainees, torture, Supreme Court nominees, warrantless wiretapping. One of these issues bears special mention as we mourn the passing of John McCain. In 2004, 2005, I joined John McCain when he led the effort to pass an amendment affirming that torture and cruel and inhuman and degrading treatment would be illegal in America. As a survivor of unspeakable torture, John McCain spoke with powerful moral authority about American values during the time of war. You were in the Bush White House when that McCain amendment passed. The Bush administration did everything in its power to stop John McCain's torture amendment. Then after we passed it 90-9, a veto-proof margin, President Bush issued a signing statement asserting his right to ignore the law that John McCain had just passed in Congress. When we met in my office, you acknowledged that you worked on that signing statement. Yet we've been denied any documents disclosing your role or your advice to President Bush. I asked you if you wrote, edited, or approved documents about these and other issues while you were staff secretary. Time and again, you said, I can't rule it out. Judge Kavanaugh, America needs to see those documents. We cannot carefully review, advise, and decide whether to consent to your nomination without clarity on the record. The period of time when you worked in the Republican White House led to a change in position on an issue which we have to address directly. Your views on executive power and accountability have changed dramatically. When you worked for Special Counsel Ken Starr in the late 1990s, you called him, quote, an American hero for investigating President Bill Clinton. And you personally urged Starr to be aggressive, confrontational, and even graphic in his questions. We've seen your memo on that one. But a few years later, after working in the Republican White House, you totally reversed your position and argued that presidents should be above the law and granted a free pass from criminal investigation while in office. What did you see in that Bush White House that dramatically changed your view? What are your views about presidential accountability today? Judge Kavanaugh, at this moment in our nation's history, with authoritarian forces threatening our democracy, with the campaign and administration of this president under federal criminal investigation, we need a direct, credible answer from you. Is this president or any president above the law? Equally important, can this president ignore the Constitution in the exercise of his authority? You dissented in the Seven Sky case when the D.C. Circuit upheld the Affordable Care Act's constitutionality. You criticized the law, a law which this president has said many times he wants to ignore and abolish. And you said, quote, the president may decline to enforce a statute that regulates private individuals when the president deems the statute unconstitutional, even if a court has held or would hold the statute constitutional. This statement by you flies in the face of Marbury versus Madison, our North Star in the separation of powers. It gives license to this president, Donald John Trump, or any president who chooses to ignore the Constitution to assert authority far beyond that envisioned by our founding fathers. There are many people who are watching carefully. I'm going to make a suggestion to you today, and it won't be popular on the other side of the aisle. If you believe that your public record is one that you can stand behind and defend, I hope that at the end of this, you will ask this committee to suspend until we are given all the documents, until we have the time to review them, and then we resume this hearing. What I'm saying to you is basically this. If you will trust the American people, they will trust you. But if your effort today continues to conceal and hide documents, it raises a suspicion. I'll close, Mr. Chairman. I know you're anxious. When I was a practicing lawyer a long time ago in trial, and the other side either destroyed or concealed evidence, I knew that I was going to be able to have a convincing argument to close that case. What were they hiding? Why won't they let you see the speed tape on that train or the documents that they just can't find? You know that presumption now is against you because of all the documents that have held back. For the sake of this nation, for the sanctity of the Constitution that we both honor, step up, ask this meeting, this gathering, to suspend until all the documents of your public career are there for the American people to see. Thank you, Mr. Chairman.
Senator Lee.
Thank you, Mr. Chairman. Thank you, Judge Kavanaugh. And thank you also, Ashley and Margaret and Eliza, for being here. I'm going to start by saying that the fact that there is so much angst over a single nominee, a single judicial nominee, tells you everything you need to know about why it is that we need judges now more than ever who are willing to read the law and interpret it based on what the law says rather than on the basis of something else. It also tells you more than anything else you could need to know about the need to restore a discussion of civics in this country, to restore a discussion about federalism and separation of powers, about where power is concentrated and where it shouldn't be, and what the role of each branch of the federal government is and is not. Many of the comments, many of the outbursts that we've had today suggest that we need to return to some of those fundamental principles. And I don't care whether you're a liberal Democrat or a conservative Republican or something in between. These principles apply. They're principles to which we have sworn an oath. And they're principles that I think we would do well to restore and focus on once again. If ever we're to return to an era of civility, we will return to that era on the basis of those foundational structural principles within our Constitution. Over the next few days, Judge Kavanaugh, a number of members of this committee are going to ask you questions. Questions about cases that you've handled as a lawyer, cases that you've decided as a judge, about your record, about your qualifications. Well, on that point about your record and your qualifications, the suggestion that you misled this committee at any point in your previous hearings is absurd. And the absurdity of that suggestion will be borne out in the coming days. I am certain of it. Some of the questions that will be asked of you will, in fact, be fair, and others will be unfair. And I think it's important for us to acknowledge that at the outset. When you look back at history, answering these kinds of questions, this is sort of how the practice of holding these hearings began, so that senators could ask nominees how they might vote, how they might rule in particular cases. But this didn't always happen. In fact, it wasn't until 1916 that this even started. You see, there have been 113 justices confirmed to the Supreme Court so far. The first 66 were confirmed without even holding a hearing. The idea of a hearing is relatively new. It's about 102 years old. We went for between 125 and 130 years under our constitutional republic without ever having a hearing. But regardless, we started having hearings just over a century ago. The very first Supreme Court confirmation hearing occurred in 1916 with Justice Louis Brandeis. After Louis Brandeis was nominated to the court, some called for a hearing. Now, if we're honest with ourselves, if we're honest about history, I think a lot of this maybe had to do with some anti-sentiment fervor and the fact that Justice Brandeis was Jewish. But senators also wanted to determine whether Brandeis would use his seat on the Supreme Court to advocate for some of the things that he had advocated for as a private citizen, as a public interest attorney. They wanted to know how he might vote in particular cases. They didn't ask Justice Brandeis to testify significantly, but they did, in fact, ask some outside witnesses what they thought about his nomination. The next important moment, one could argue, occurred in 1939, when Felix Frankfurter became the first nominee to himself testify before the committee. At the time, Frankfurter was controversial in part because he was born overseas, but senators also worried that Frankfurter was a radical based on his defense of anarchists in court. So again, senators wanted assurances about how Frankfurter might rule in particular cases, in particular what results he might reach in a particular type of case. Frankfurter, however, significantly declined to engage with senators on those topics and insisted that his public record spoke for itself. Justice Stewart's nomination in 1959 was another turning point. Senators seeking to resist Brown versus Board of Education wanted to grill Stewart on his views on integration. Others still wanted to grill Stewart about his views on national security. So senators turned up the heat a little bit more in that hearing. Like Frankfurter before him, Justice Stewart did not provide substantive answers to their questions. When they wanted to know how he might rule in particular cases, he appropriately declined, just as his predecessors had. 28 years later, 28 years after Justice Stewart came through this committee, the Senate considered Robert Bork's nomination to the Supreme Court. This was another significant turning point. And in my view, it remains something of a rock bottom moment for the Senate and for the Senate Judiciary Committee. Without getting into any of the gory details here, I think it suffices to say that Senator Ted Kennedy and Judge Bork did not agree on certain matters of constitutional law. And Kennedy's response was to savage, unfairly in my opinion, the results that Judge Bork would reach if confirmed to the Supreme Court. The history shows that over the better part of a century, the Judiciary Committee has gradually created something of a new norm, a norm in which members demand that nominees speak about specific cases in return for favorable treatment from the committee as the jurists are going through this process. Now, nominees, for the most part, have gracefully resisted trading confirmation in exchange for promises about how they might vote in particular cases brought before them. To give two famous examples, Justice Scalia refused to say whether Marbury versus Madison was settled law on the ground that it could come before him. And sure enough, last term in Ortiz versus United States, the Supreme Court considered a case implicating the scope of Marbury. Likewise, Justice Ruth Bader Ginsburg created the so-called Ginsburg standard. No previews, no forecasts, no hints. Every current member of the Supreme Court has adhered to a similar principle, what we might call the Ginsburg standard. Even though nominees have not caved to the pressure, I still believe that there are some aspects of the Senate's approach here that might do a disservice to the country and might be frowned upon by future historians. If senators repeatedly ask nominees about outcomes, then the public will be more entitled, or at least more inclined, to think that judges are supposed to be outcome-minded, that that's supposed to be their whole approach to be to judging, that that's supposed to be what judging is in fact about. But this, of course, undermines the very legitimacy of the courts themselves. the very legitimacy of the tribunal that you've been nominated by the President to serve on. Over time, no free people would accept a judiciary that simply imposes its own policy preferences on the country, absent fidelity to legal principle. There's a better way for the Senate to approach its work. This process, in my opinion, should be about your qualifications, about your character, and perhaps most importantly, about your approach to judging, your own view about the role of the federal judiciary. It should not be about results in a select number of cases. Now, you're obviously exceptionally well qualified. Even your staunchest critics would not claim otherwise. Your academic pedigree, your experience as a practicing lawyer, your experience in government, and your 12 years experience sitting on what many refer to as the second highest court in the land, the U.S. Court of Appeals for the D.C. Circuit. You are independent. You've written that, quote, some of the greatest moments in American judicial history have been when judges stood up to the other branches, were not cowed, and enforced the law, close quote. You've said that judges cannot be buffaloed, influenced, or pressured into worrying too much about transient popularity when we are trying to decide a case, and that one of the most important duties of a judge is to stand up for the unpopular party who has the correct position. And you've lived up to your words during your time on the bench. Everyone knows that you served in the Bush administration. And yet, when you became a judge, in only 2 years, you ruled against the Bush administration a total of 8 times. For you, it simply doesn't matter who the parties are. It simply doesn't matter that you may have worked for an administration before you became a judge. The only thing that matters is your commitment to correctly applying the law to the facts of any particular case. As far as your approach to judging, you have appropriate respect for precedent. You've co-authored an 800-page book on precedent that, among other things, explains that a change in a court's membership alone should not throw former decisions open to reconsideration or justify their reversal. You've explained that for precedent to be overruled, it must not be just wrong, but a case with serious practical consequences. You voted to overturn circuit precedent only 4 times during your time on the D.C. Circuit, and each of those cases involved a unanimous decision reached by your colleagues. And you follow binding precedent, even if you believe that binding precedent was itself wrongly decided. You decide cases based on legal merits, not based on the identity of the parties, and certainly not based on any political beliefs that you may harbor. We've already heard that your nomination will somehow be bad for women, for the environment, for labor unions, for civil rights, for a whole host of other things that Americans hold near and dear. I have a laundry list of cases in which you've ruled for people in each of those groups. But there's a more fundamental point here that I think needs to be made. The judiciary's decisions are legitimate only to the extent that they're based on sound legal principle and reasoning. And ruling for a preferred party is not itself a sound legal principle. It's quite to the contrary. Jury rigging decisions and backfilling legal reasoning to reach a particular result, a particularly politically acceptable result in a particular case, no matter how desirable that result might be in any instance, is not a legitimate mode of judicial decision-making. And no free people purporting to have an independent judiciary should ever be willing to settle for that. So my plea to my colleagues today is that we ask Judge Kavanaugh hard questions. I believe we're required to do so. The Senate is not and never should be a rubber stamp, particularly when it comes to issuing lifetime appointments, even lifetime appointments on the highest court in the land. But if you disagree with an opinion he's written, make a legal argument as to that issue. Explain why you think it's wrong. Don't complain about the results as if the result itself is proof that he's wrong when you separate out the result from the legal analysis, from the facts and how they interact with the law in that particular case. And don't ask him to make promises about outcomes in particular cases. If it's unacceptable for the president to impose a litmus test, it is surely unacceptable for the United States Senate to do so. Judge Kavanaugh, I look forward to your testimony, and I'm grateful to you and your willingness to serve our country and to be considered for this important role.
Senator Whitehouse.
Thank you, Mr. Chairman. When is pattern evidence of bias? In court, pattern is evidence of bias all the time, evidence on which juries and trial judges rely to show discriminatory intent, to show a common scheme, to show bias. When does a pattern prove bias? I wish this were an idle question. It's relevant to the pattern of the Roberts Court when its Republican majority goes off on partisan excursions through the civil law. That is, when all 5 Republican appointees, the Roberts 5 we can call them, go raiding off together and no Democratic appointee joins them. Does this happen often? The Roberts 5 has gone on almost 80 of these partisan excursions since Roberts became chief. That's a lot of times. And there's a feature to these 80 cases. They almost all implicate interests important to the big funders and influencers of the Republican Party. When the Republican justices go off on these 5 justice partisan excursions, there's a big Republican corporate or partisan interest involved 92% of the time. The tiny handful of these cases that don't implicate an interest of the big Republican influencers is so flukishly few that we can set them aside. Let's look at the 73 cases that all implicate a major Republican Party interest. Again, 73 is a lot of cases at the Supreme Court. Is there a pattern to these 73 cases? Oh, yes, there is. Every time a big Republican corporate or partisan interest is involved, the big Republican interest wins. Every time. Let me repeat. In 73 partisan decisions where there's a big Republican interest at stake, the big Republican interest wins. Every damned time. Thus, the mad scramble of big Republican interest groups to protect a Roberts 5 that will reliably give them wins. Really big wins sometimes. I note that when the Roberts 5 saddles up, these so-called conservatives are anything but judicially conservative. They readily overturn precedent, toss out statutes passed by wide bipartisan margins, and decide on broad constitutional issues that they need not reach. Modesty, originalism, stare decisis, all these supposedly conservative judicial principles all have the hoofprints of the Roberts 5 all across their backs, wherever those principles got in the way of those wins for the big Republican interests. The litany of Roberts 5 decisions explains why big Republican interests want Judge Kavanaugh on the court so badly. So badly that Republicans trampled so much Senate precedent to push him through. So let's review the highlights reel. What do big Republican interests want? Well, first, they want to win elections. What has the Roberts Five delivered? Help Republicans gerrymander elections. Veith v. Jubileer, 5-4. License to gerrymander. Help Republicans keep minority voters away from the polls. Shelby County, 5-4, and Bartlett v. Strickland, 5-4, and Abbott v. Perez, 5-4, despite the trial judge finding the Texas legislature actually intended to target and suppress minority voters. And the big one, help corporate front group money flood elections. Big money interests love unlimited power to buy elections, lobby, and threaten and bully Congress. McCutcheon, 5-4, counting the concurrence, Bullock, 5-4, and the infamous, grotesque 5-4 Citizens United decision, which I believe stands beside Lochner on the court's roll of shame. What else do big influencers want? To get out of courtrooms. Big influencers hate courtrooms because they're lobbying and electioneering and threatening doesn't work, or at least it's not supposed to. In a courtroom, big influencers used to getting their way have to suffer the indignity of equal treatment. So the Roberts Five protects corporations from group class action lawsuits. Walmart v. Dukes, 5-4. Comcast, 5-4. And this past term, Epic Systems, 5-4. The Roberts Five helps corporations steer customers and workers away from courtrooms and into mandatory arbitration. Concepcion, Italian Colors, and Rent-A-Center, all Roberts Five. Epic Systems does double duty here because now workers can't even arbitrate their claims as a group. Hindering access to the courthouse for plaintiffs generally. Iqbal, 5-4. Protecting corporations from being taken to court by employees. Harmed through pay discrimination, Ledbetter, 5-4. Age discrimination, Gross, 5-4. Harassment, Vance, 5-4. And retaliation, Nassar, 5-4. Even insulating corporations from liability for international human rights violations, Jessner, 5-4. Corporations aren't in the Constitution. Juries are. Indeed, courtroom juries are the one element of American government designed to protect people against encroachments by private wealth and power. So, of course, the Roberts Five rules for wealthy, powerful corporations over jury rights every time, with nary a mention of the Seventh Amendment. What's another one? Oh, yeah, a classic, helping big business bust unions. Harris v. Quinn, 5-4, and Janus v. AFSCME this year, 5-4, overturning a 40-year precedent. Lots of big Republican influencers are polluters who like to pollute for free. So the Roberts Five delivers partisan decisions that let corporate polluters pollute. To pick a few, Rapanos, weakening wetland protections, 5-4. National Association of Home Builders, weakening protections for endangered species, 5-4. Michigan v. EPA, helping air polluters, 5-4. And in the face of emerging climate havoc, there's the procedurally aberrant 5-4 partisan decision to stop the EPA Clean Power Plan. Pattern. Then come Roberts Five bonus decisions advancing a far-right social agenda. Gonzalez v. Carhart, upholding restrictive abortion laws. Hobby Lobby, granting corporations religious rights over the health care rights of their employees. NIFLA, letting states deny women truthful information about their reproductive choices. All 5-4, all Republican. Add Heller and McDonald, which reanimated for the gun industry a theory a former Chief Justice once called a fraud. Both decisions 5-4. This year, Trump v. Hawaii, 5-4, rubber stamping the Muslim travel ban. And in case Wall Street was feeling left out, helping insulate investment bankers from fraud claims, Janus Capital, 5-4. Pattern. No wonder the American people feel the game is rigged. Here's how the game works. Big business and partisan groups fund the Federalist Society, which picked Gorsuch and now you. As the White House counsel admitted, they insourced the Federalist Society for this selection. Exactly how the nominees were picked and who was in the room where it happened and who had a vote or a veto and what was said or promised, that's all a deep, dark secret. Then big business and partisan groups fund the Judicial Crisis Network, which runs dark money political campaigns to influence senators in confirmation votes, as they've done for Gorsuch and now for you. Who pays millions of dollars for that and what their expectations are is a deep, dark secret. These groups also fund Republican election campaigns with dark money and keep the identity of big donors a deep, dark secret. And of course, 90% of your documents are to us a deep, dark secret. Then once the nominee's on the court, the same business front groups with ties to the Koch brothers and other funders of the Republican political machine file friend of the court or amicus briefs to signal their wishes to the Roberts Five. Who is really behind those friends is another deep, dark secret. It has gotten so weird that Republican justices now even send hints back to big business interests about how they'd like to help them next. And then big business lawyers rush out to lose cases, just to rush up before the friendly court pronto. That's what happened in the Friedrichs Janus episode. The U.S. Chamber of Commerce is the biggest corporate lobby of them all. For big coal, big oil, big tobacco, big pharma, big guns, you name it. And this year, with Justice Gorsuch riding with the Roberts Five, the chamber won 9 out of 10 cases it weighed in on. The Roberts Five since 2006 has given the chamber more than 3/4 of their total votes. This year, in all civil cases, they voted for the chamber's position fully 90% of the time. And in these 5-4 cases I've highlighted, 100%. People are noticing. Veteran court watchers like Jeffrey Toobin, Linda Greenhouse, and Norm Ornstein described the court's service to Republican interest. Toobin wrote that on the Supreme Court, Roberts has served the interests of the contemporary Republican Party. Greenhouse has said the Republican-appointed majority is committed to harnessing the Supreme Court to an ideological agenda. Ornstein described the new reality of today's Supreme Court. It is polarized along partisan lines in a way that parallels other political institutions and the rest of society in a fashion we have never seen. And the American public knows it too. The American public thinks the Supreme Court treats corporations more favorably than individuals compared to vice versa by a 7-to-1 margin. 49% of Americans think corporations get special treatment there. Now let's look at where you fit in. A Republican political operative your whole career who's never tried a case. You made your political bones helping the salacious prosecution of President Clinton and leaking prosecution information to the press. As an operative in the second Bush White House, you cultivated relationships with political insiders like nomination guru Leonard Leo, the Federalist Society architect of your court nominations. On the D.C. Circuit, you gave more than 50 speeches to the Federalist Society. That looks like auditioning. On the D.C. Circuit, you showed your readiness to join the Roberts Five with big political wins for Republican and corporate interests. Unleashing special interest money into elections, protecting corporations from liability, helping polluters pollute, striking down common sense gun regulations, keeping injured plaintiffs out of court against corporations, and perhaps most important for the current occupant of the Oval Office, expounding a nearly limitless vision of presidential immunity from the law. Your alignment with right-wing groups who came before you as friends of the court, 91%. When big business trade associations weighed in, 76%. This, to me, is what corporate capture of the courts looks like. There are big expectations for you. The shadowy dark money front group, the Judicial Crisis Network, is spending tens of millions in dark money to push for your confirmation. They clearly have big expectations. about how you'll rule on dark money. The NRA has poured millions into your confirmation, promising their members that you'll break the tie. They clearly have big expectations on how you'll vote on guns. White House counsel Don McGahn admitted there is a coherent plan here where actually the judicial selection and the deregulatory effort are really the flip side of the same coin. Big polluters clearly have big expectations for you on their deregulatory effort. Finally, you come before us nominated by a president named in open court as directing criminal activity and a subject of ongoing criminal investigation. You displayed expansive views on executive immunity from the law. If you are in that seat, sir, because the White House has big expectations that you will protect the president from the due process of law, that should give every senator pause. Tomorrow we'll hear a lot of confirmation etiquette. It's mostly a sham. You know the game. In the Bush White House, you coached judicial nominees to just tell senators that they have a commitment to follow Supreme Court precedent, that they will adhere to statutory text, that they have no ideological agenda, end quote. Fairy tales. At his hearing, Justice Roberts infamously said he'd just call balls and strikes. But this pattern, 73-0 of the Roberts 5, qualifies him to have NASCAR-style corporate badges on his robes. Alito said in his hearing what a strong principle stare decisis was, an important limitation on the court. Then he told the Federalist Society, stare decisis means to leave things decided when it suits our purposes. Gorsuch delivered the key fifth vote in the precedent-busting and union-busting Janus decision. He, too, had pledged in his hearing to follow the law of judicial precedent, assured us he was not a philosopher king, and promised to give equal concern to every person, poor or rich, mighty or meek. How'd that turn out? Great for the rich and mighty. Gorsuch is the single most corporate-friendly justice on a court already full of them, ruling for big business interests in over 70% of cases and in every single case where his vote was determinative. The president early on assured evangelicals his Supreme Court picks would attack Roe v. Wade. Despite confirmation etiquette assurances about precedent, your own words make clear you don't really believe Roe versus Wade is settled law, since the court, as you said, can always overrule its precedent. Mr. Chairman, we've seen this movie before. We know how it ends. The sad fact is that there is no consequence for telling the committee fairy tales about stare decisis and then riding off with the Roberts 5, trampling across whatever precedent gets in the way of letting those big Republican interests keep winning 5-4 partisan decisions. 73-0, Mr. Kavanaugh, every damned time. Thank you, Mr. Chairman.
Yeah. Senator Cruz.
Chairman, I have some documents to support this. May I ask unanimous consent they be entered into the record?
They without objection,
Thank you.
entered.
Thank you, Mr. Chairman. Judge Kavanaugh, welcome. Welcome to your family, to your friends, demonstrating your good judgment. Your wife was born and raised in West Texas, and you and she have been friends of Heidi and mine for 20 years. Thank you for your decades of public service. And I'm sorry that your daughters had to endure the political circus of this morning. That is, alas, the world that is Washington in 2018. I want to discuss what this hearing is about and what it's not about. First, this hearing is not about the qualifications of the nominee. Judge Kavanaugh is, by any objective measure, unquestionably qualified for the Supreme Court. Everyone agrees he's one of the most respected federal judges in the country. He has impeccable academic credentials, even if you did go to Yale. And you've served over a decade on the U.S. Court of Appeals for the D.C. Circuit, often referred to as the second highest court in the land. So our Democratic colleagues are not trying to make the argument that Judge Kavanaugh is not qualified. Indeed, I haven't heard anyone even attempt to make that argument. Second, this hearing is not about his judicial record. Judge Kavanaugh has over 300 published opinions, which altogether amount to over 10,000 pages issued in his role as a federal appellate judge. Everyone agrees a judge's record is by far the most important indicium of what kind of justice that nominee will be. And tellingly, we've heard very little today from Democratic senators about the actual substance of Judge Kavanaugh's judicial record. Third, it's important to understand today is also not about documents. We've heard a lot of arguments this morning about documents. There's an old saying for trial lawyers: if you have the facts, pound the facts. If you have the law, pound the law. If you have neither, pound the table. We're seeing a lot of table pounding this morning. The Democrats are focused on procedural issues because they don't have substantive points strong enough to derail this nomination. They don't have substantive criticism with Judge Kavanaugh's actual judicial record, so they're trying to divert everyone with procedural issues. But let's talk about the documents for a moment. The claims that the Democrats are putting forward on documents don't withstand any serious scrutiny. Judge Kavanaugh has produced 511,948 pages of documents. That includes more than 17,000 pages in direct response to this committee's written questionnaire, which is the most comprehensive response ever submitted to this committee. The more than 500,000 pages of documents turned into this committee is more than the number of pages we've received for the last 5 Supreme Court nominees combined. Listen to that fact again. The over 500,000 documents turned over to this committee is more than the last 5 nominees submitted to this committee combined. So what's all the fuss over the documents that are not turned over? Most of those concern Judge Kavanaugh's 3 years as the staff secretary for President George W. Bush. Now, many people don't know what a staff secretary does, but that's the position in charge of all of the paper that comes into and out of the Oval Office. Critically, the staff secretary is not the author of the paper coming into and out of the Oval Office. That paper is typically written by the Attorney General, by the Secretary of State, by other cabinet members, by other senior White House officials. The staff secretary is simply the funnel for collecting their views and then for transferring the paper back and forth. In other words, those documents written by other people say nothing, zero, about Judge Kavanaugh's views, and they say nothing, zero, about what kind of justice Judge Kavanaugh would make. But they are, by necessity, the most sensitive and confidential documents in a White House. They are the documents that are going to the president. This is the advice and deliberations of the president at the senior level, and the staff secretary is the conduit for those documents. So why is it that the Democrats are putting so much energy in saying, hand over all of those documents? Because they know beyond a shadow of doubt that President George W. Bush's White House team is not going to allow every piece of paper that went to the president to be made public any more than any other White House would. Republican or Democrat, no White House would allow every piece of paper that went to and from the president to be made public. Indeed, there are rules and laws and procedures for when and how presidential papers become public. And the reason the Democrats are fighting so loudly on this issue is they're making a demand they know is impossible to meet, and by the way, is utterly irrelevant to what actually Judge Kavanaugh thinks, believes, or has said. It would open up all sorts of fishing expeditions to attack, relitigate George W. Bush's record as president and what various cabinet members and senior advisors might or might not have said. But it is, at the end of the day, simply an attempt to distract and delay. And indeed, the multiple motions we've seen from Democrats, delay this confirmation, that reveals the whole joke. Their objective is delay. So what is this fight about? If it's not about documents, if it's not about Judge Kavanaugh's credentials, if it's not about his judicial record, what is this fight about? I believe this fight is nothing more and nothing less than an attempt by our Democratic colleagues to relitigate the 2016 presidential election. 2016 was a hard-fought election all around. And it was the first presidential election in 60 years where Americans went to the polls with a vacant seat on the Supreme Court, one that the next president would fill. Americans knew who had been in that seat, the late Justice Antonin Scalia, one of the greatest jurists ever to sit on the U.S. Supreme Court. And it was the first time since President Dwight D. Eisenhower's re-election campaign that a Supreme Court seat was directly on the ballot. Both candidates knew the importance of the vacant Supreme Court seat, and it was a major issue of contention in the presidential election. Donald Trump and Hillary Clinton were both clear about what kind of justices and judges they would appoint. During all three presidential debates, both candidates were asked what qualities were most important to them when selecting a Supreme Court justice. Secretary Clinton's answer was clear. She wanted a Supreme Court justice who would be a liberal progressive, willing to rewrite the U.S. Constitution, willing to impose liberal policy agendas that she could not get through the democratic process, that the Congress of the United States would not adopt, but that she hoped 5 unelected lawyers would force on the American people. That's what Hillary Clinton promised for her judicial nominees. Then candidate Donald Trump gave a very different answer. He said he was looking to appoint judges in the mold of Justice Scalia. He said he wanted to appoint judges who would interpret the Constitution based on its original public meaning, who would interpret the statutes according to the text, and who would uphold the rule of law and treat parties fairly, regardless of who they are or where they come from. Then candidate Donald Trump also did something that no presidential candidate has done before. He published a list of nominees that he would choose from when filling Justice Scalia's seat, providing unprecedented transparency to the American people. All of this was laid before the American people as they went to the polls on November 8th, 2016. And the American people made a choice that night. Now, my Democratic colleagues are not happy with the choice the American people made. But as President Obama famously said, elections have consequences. Because the American people had the chance to vote, a national referendum on the direction of the Supreme Court. I've said a number of times that Justice Gorsuch's nomination and Judge Kavanaugh's nomination have almost a super legitimacy in that they were ratified, they were decided by the American people in a direct vote in 2016. And so the Democratic obstruction today is all about trying to reverse that election. They're unhappy with the choice the American people want. And there's a reason that the American people want strong constitutionalists on the U.S. Supreme Court. Most Americans, and I know the overwhelming majority of Texans, want judges who will follow the law and will not impose their policy preferences on the rest of us, and who will be faithful to the Constitution and the Bill of Rights. Justices who will uphold fundamental liberties like free speech, like religious liberty, like the Second Amendment. That's what this election was about. And if you look at each of these, let's take free speech. It's worth noting that in 2014, every Democratic member of this committee voted to amend the United States Constitution to repeal the free speech provisions of the First Amendment. And sadly, every Democrat in the Senate agreed with that position, voting to give Congress unprecedented power to regulate political speech. It was a sad day for this institution. Years earlier, Ted Kennedy, the great liberal lion, had opposed a very similar effort. And Ted Kennedy had said, "We haven't amended the Bill of Rights in over 200 years. Now is no time to start." Ted Kennedy was right then, and not a single Democrat in the U.S. Senate had the courage to agree with Ted Kennedy and support free speech. Indeed, they voted party line to repeal the free speech provisions of the First Amendment. That is radical, that is extreme, and it's part of the reason the American people voted for a president who would put justices on the court who will protect our free speech. How about religious liberty? Religious liberty is another fundamental protection that the Democrats in the Senate have gotten extreme and radical on. Indeed, our Democratic colleagues want justices who will rubber stamp efforts like the Obama administration's efforts litigating against the Little Sisters of the Poor, litigating against Catholic nuns trying to force them to pay for abortion-inducing drugs and others. That is a radical and extreme proposition. And to show just how dramatic Senate Democrats have gotten, every single Senate Democrat just a few years ago voted to gut the Religious Freedom Restoration Act, legislation that passed Congress with overwhelming bipartisan support in 1993, was signed into law by Bill Clinton, and yet 2 decades later, the Democratic Party has determined that religious freedom is inconvenient for their policy and political objectives. They want justices that will further that assault on religious liberty. And finally, let's take the Second Amendment. In the presidential debates, Hillary Clinton explicitly promised to nominate justices who would overturn Heller versus District of Columbia. Heller is the landmark decision issued by Justice Scalia, likely the most significant decision of his entire tenure on the bench, and it upheld the individual right to keep and bear arms. Now, Hillary Clinton was quite explicit. She wanted judges who would vote to overturn Heller, and indeed a number of our Democratic colleagues, that's what they want as well. Overturning Heller, I believe, would be a truly radical proposition. To understand why, you have to understand what the 4 dissenters said in Heller. The 4 dissenters in Heller said that the Second Amendment protects no individual right to keep and bear arms whatsoever, that it protects merely a collective right of the militia. The consequence of that radical proposition would mean that Congress could pass a law making it a felony, a criminal offense for any American to own any firearm. And neither you nor I nor any American would have any individual right whatsoever under the Second Amendment. It would effectively erase the Second Amendment from the Bill of Rights. That is a breathtakingly extreme proposition. It is what Hillary Clinton promised her justices would do. And at the end of the day, it's what this fight is about. We know that every Democratic member of this committee is going to vote no. We don't have to speculate. Every single one of them has publicly announced they're voting no. Doesn't depend on what they read in documents, doesn't depend on what Judge Kavanaugh says at this hearing. They've announced ahead of time they are voting no, and most of the Democrats in the Senate have announced that in the full Senate. But everyone should understand Judge Kavanaugh has handed over more documents than any nominee. More than the last 5 combined, Republican and Democratic nominees. It's not about documents. It's not about qualification. It's not about record. What it is about is politics. It is about Democratic senators trying to relitigate the 2016 election and, just as importantly, working to begin litigating the 2020 presidential election. But we had an opportunity for the American people to speak. They did. They voted in 2016, and they wanted judges and justices who will be faithful to the Constitution. That's why I'm confident at the end of what Shakespeare would describe as a lot of sound and fury signifying nothing, I am confident that Judge Kavanaugh will become Justice Kavanaugh and will be confirmed to the United States Supreme Court. Thank you, Mr. Chairman.
Okay. We're going to take a break now. And wait a minute. We're going to take a break now, and 30 minutes is what the Democrats would like to have, so we will return at 1:17, and Gorsuch returned about 10 minutes later than that, so be on time, please.
Not Gorsuch. You said Gorsuch.
Yeah, well.